This is the June 10th Metropolitan Traffic and Parking Commission. If you are not satisfied with the decision made by the Traffic and Parking Commission, you may appeal the decision by filing for a writ of certiorari with the Davidson County Chancery or Circuit Court. Your appeal must be filed within 60 days of the date of the entry of the Commission's decision. We advise that you seek your own independent legal advice to ensure that your appeal is filed in a timely manner and that all procedural requirements have been met. Do I have a motion for approval of today's agenda?
Move to approve.
Do we have a second?
Second.
There's been first and second. All in favor? Any opposed? It is passed. Item 3.0, approval of last month's meeting minutes. Do we have a motion?
Motion to approve.
We have a second?
Second.
It's been first and second. All in favor say aye.
Aye.
Any opposed? It is passed. I believe we had a sign-in sheet. Do we have anybody sign in? I think we forgot to grab that. So we would like to welcome our new commissioner, Mr. Robert Gibbs, to the commission. We appreciate you being here. Look forward to serving with you on this commission. If you have any questions or comments or anything, please do not hesitate to ask, and look forward to your input. Thank you for being here. So is there anybody in the audience that has any comments that's not related, public comment not related to the current agenda? Councilman Coopin, come forward, please. If you don't mind, state your name for the record. Whichever one has a mic, if you don't mind. That works.
All right, appreciate it. Thank you. Thanks for allowing me to speak for a few moments. Just wanted to address the recent questions and concerns around the tourism improvement zone. I know that there'll be some conversation around this later today. I asked to have NDOT and/or MDHA speak a little bit on this, but wanted to share some background. When the businesses on 2nd Avenue shared their struggles in generating pedestrian traffic after the bombing and construction, I worked with these departments to create a program that would allow for vending, lights, sandwich boards, other improvements, generating buzz along the street. And as y'all know, the government does not move quickly. And so this took months to kind of get together and get off the ground, and there were a number of different iterations, and somewhere along, I know now because I retraced the steps, that somewhere along the way, some language was entered that kind of basically said the bill closed the road, and then that made its way to the caption that y'all saw and into the bill on the floor of the council. And I became aware of this around the time of second reading because people were saying, hey, this is really incredible. We're pedestrianizing 2nd Avenue and making a space that's pedestrian only, and this is a really cool pilot. And kind of wish we had that idea in hindsight because it's a super cool idea and concept, and something that I explored a little bit further but wasn't able to kind of go back and create at this point given the origin of the bill. But I kind of looked into it, and the way the bill was written, it gave NDOT the permission to close or open the road as they wanted to. So the bill itself would have allowed for them to follow the Connect Downtown plan and the 2nd Avenue plan to reopen the road. But kind of given the public question and public excitement over something that wasn't going to happen, I felt that it was important to clarify that. Tried to get the amendment on second reading, but it was late filed, so they asked me, Rules Committee asked me to run it on third, so I presented a number of committees about the nature of the change. Again, intended just to clarify the original intention. But at the end of the day, this is my bill, and so I kind of carry full responsibility for getting it right. And the reason I'm here to speak about it is I don't think we got it right. I think that looking back at the agenda that y'all saw, looking back at the caption that y'all saw was not clear as to the intention of the bill, and that's not pointing fingers or fault. I think just kind of the nature of the beast a little bit, but wanted to kind of be here to clarify it. And I, again, asked NDOT and MDHA to speak a little later to address it. I do want to highlight that there are wider sidewalks and raised crosswalks along 2nd Avenue, and that this tourism zone, again, the remainder of the project is closed to pedestrian traffic, but not as a pedestrianized zone. It's closed because there's construction and chopped up street and broken concrete and things like that. But that being said, I extend to all of you guys and anybody watching at home or listening the opportunity. Would love to walk neighborhoods downtown or anywhere throughout my district. Looking at it from a bike perspective, looking at it from a walking perspective, I think pedestrianization and the conversation on pedestrian safety is incredibly important. It's a great concept. I think it's things we need to continue to look at. I've spoken to MDHA and NDOT about ways on this 2nd Avenue project we can continue to bring pedestrian safety. And again, my door remains open to all of y'all to discuss it. So thank you very much.
Appreciate those comments. We have under other items as a line item to talk about this, and welcome MDHA and NDOT to speak further to it. Appreciate your efforts to ensure that the local businesses and tourists can safely attend and frequent those spaces. As this commission's focus is on pedestrian safety, that is paramount and very well important to whatever comes to fruition for this. So appreciate you making those comments.
Thank you.
We'll move on to item 5.0, approval of the consent agenda. Item 5.1, authorization for new truck restriction, no trucks over 8 tons on Preston Road from Pettis Road to Old Franklin Road, requested by NDOT. Authorization for a new truck restriction, no trucks over 8 tons on Pettis Road from Old Hickory Boulevard to Old Hickory Boulevard, requested by NDOT. Authorization for a new truck restriction, no trucks over 8 tons on Blue Hole Road from Bell Road to Pettis Road, requested by NDOT. Approval for a new pedestrian hybrid beacon on Dickerson Pike at Rock Street, requested by NDOT. And then approval for relocation of existing valet lane for Union Street to 304th Avenue North, and no parking restrictions on the north side of Union Street, requested by NDOT. Do we need to pull any of these items out for discussion?
I just have a question.
Sure.
I think might answer whether or not they need to be pulled out. 5.1 and 5.2 were noticed with the wrong road names, and I just wanted to make sure that legal is comfortable that notice was sufficient on those and that we don't need to defer them.
So are you talking about from like an open meetings compliance perspective? Yeah, I think that's probably fine. Both street names were on there, albeit in the wrong agenda item. So I think that people who are interested in those streets would still have been aware enough to like make this meeting the time that they scheduled to come down. So I don't think that that's a particularly worrisome concern, but thanks for asking.
Okay, thank you. I just want to make sure we had that on the record in case it came up. So I don't need to pull those.
Thank you for that question.
Move
Go
to
ahead, Nick.
approve.
Hold tight, Neil's got a,
Oh, I'm sorry.
I think I do want to pull 5.5 just for a quick discussion.
okay. We will pull out 5.5 as an independent item. Any others within this? So I will request a motion to approve items 5.1 through 5.4 under the consent agenda.
So moved.
Do we have a second?
Second.
All in favor, say aye. Aye. Any opposed? It is passed. Okay, so item 5.5, Mr. Mateus, would you mind coming up and speaking to this item? I guess we'll let him speak, and then we'll ask questions from the commission, and then we'll roll from there.
Good afternoon, everybody. Emmanuel Matias, NDOT. So yes, this item is for relocation of a valet lane from Union Street to improve the traffic flow we had several complaints, and also our findings through our engagement with compliance officers was that this scenario during peak times creates a bottleneck for vehicles that are coming between 3rd and 4th Avenue. And so along with the operator of the valet, we agreed that it would be best to move it to the 4th Avenue to create another lane of traffic on Union Street. And then that would also allow for no parking signs to be placed along the along the whole area from between the 3rd and 4th Avenue, and make it no parking, so that the issues that we currently encounter would be alleviated.
Thank you. Questions from the commission?
So I wanted to pull it and just kind of hear our thoughts on this. So this section is a big part of Connect Downtown, and I think a lot of it is in the first phase. One part of the first phase is Union Street is potentially getting a multimodal path, bike lane, whatever we're going to call it now, which is great that we're, kind of removing some of the space to be able to fit that. On 4th Avenue, it does look like we're trying to do a queue jump for buses. Can you explain if the queue jump was kind of thought through on this valet lane, and if we're going to create any sort of issues in the near term by putting it there?
I don't think it's going to create an issue, because we also have spaces that we manage behind this area, which are taxi spaces right now. So behind the entrance of the UBS tower, I think for the time being, we were looking at addressing Union first, and 4th Avenue would have been, 4th Avenue is just something that we are able to do at this point without canceling the valet location on its entirety. There was no other way to have this location still operational without making this step. So I don't know if that answered the question. We might have to have some further discussions about this in the future. Also, as a reminder, everything that is approved is valid for a year, so we can revisit this when needed.
Yeah, I mean, I don't know what the queue jump would look like at that intersection and how much space it would take up. I know the bus stop is right there. That might be a quick, easy win, and I don't know how quickly we were going to start implementing some of that stuff.
I don't have that information offhand. I can't speak to it, unfortunately, but I'll be happy to look into it and report back.
Okay.
The queue jump related to the Connect Downtown is a future implementation, right? Or is that something that's there now?
Yes, it's correct.
Okay. It's future? It's not
Future.
there now? Okay.
Yeah, future as in phase 1. Right. So that's within the next 3 years. So just to keep in mind as we talk through with the valet operator that this area may or may not be feasible in the very near future.
Correct. 3 years is a long time, so I'm sure we'll be actively in communication about anything that would pop up in the near future, and make sure that we make adjustments accordingly.
Any other questions on this item? Okay, with that, I will ask for a motion on item 5.5.
So moved.
We have a second?
Second.
It's been first and second. Any questions on the or comment on the motion? Not all in favor?
Aye.
Any opposed? It is passed. Thank you, Mr. Mateus. So we will move into item 6.0, our regular agenda. We have some fresh faces on our commission, and we deemed it appropriate for legal to just provide some refreshers around our ethics and procedures with relation to the commission. If you don't mind.
Can y'all hear me? Is that working?
We
Okay.
can.
All right, great. So I did email Mr. Bowden a PowerPoint presentation. So hopefully we can put it on the screens and y'all can follow along. But basically, this was a recommendation that came out of like a mayoral analysis a couple of years ago. And the idea is for the legal department to kind of continuously be refreshing the commissioners of all of the boards and commissions of the metro government on the issues that you all deal with a lot. And it's not just ethics, although it does absolutely include that. But like we were talking about a little bit earlier, open meetings, open records, maybe a little bit of Robert's Rules of Order, just kind of the issues that come before you a lot. And since we do have, like the chair said, some fresh faces on this board, we thought it would be a good time to redo it. I'm gonna give them a minute to see if we can get the technology working. So apologies to those of you who have heard this already, but that's okay. It's always good to get a refresher. Do I need to resend that, y'all? Okay, perfect. Thank you. There we go. That is it. Okay, if you'll go down to the next slide, Corby. Thank you. So we have multiple goals of this training, as I was just saying. In terms of ethics, the ethics ordinance in the Metro Code does kind of focus on like financial interests and concerns, like that kind of conflict of interest. So it kind of helps you understand, like in terms of like if people try to give you something, and you think they're giving it to you because you're a commissioner, like what you can take and what you shouldn't take and so forth. It also helps you understand when you might be biased or need to recuse yourself from a vote on something. Also helps you remember to disclose any outside knowledge that you've received about any matters that come before this commission, and helps the legal department by encouraging you to articulate specific reasons and factual basis for the decisions that you make. Is that not working?
It's working up there, it's just not working on our screen.
Screen from here down.
Here, switch with me, Erica, then she can look online.
Oh, my bad.
Okay. All right, good. All right, never mind. Maybe scooch over and share. All right, and then, so yeah, the more kind of factual evidence-based reasons you can give for the votes that you take makes your decisions a little more bulletproof on appeal, because as the chair was reciting at the beginning of the meeting, all of your decisions can be appealed by writ of certiorari. And understand the Open Meetings Act, understand the Public Records Act, and best practices. So going down from that, one more slide, to the understanding benefits is the next one, I think. Yeah. Okay, so Metro Code Chapter 2222 is the chapter of the Metropolitan Code that contains the ethics ordinance, and most of the pertinent stuff in there is actually in 2222 section 020, so that's a lot of twos. But basically, some general concepts of things that you should not do under that ordinance are accept or solicit any benefit that might reasonably tend to influence you to act improperly in the discharge of your official duties, use Metro property services or funds for personal purposes, use non-public Metro information for personal gain or for the gain of any family member or other employer. And then one more slide, thank you. Wait, I didn't go. I'm like, well, mine's not changing because I didn't do it. Use the Metro position improperly to secure unwarranted privileges or exemptions for themselves, relatives, or others. Accept other employment which might impair your independent judgment in the performance of your Metro duty. Accept any benefit which you, and it says the employee here, and all throughout section 020, it does refer to the employee. But if you go back to section 010, the term the employee is defined to include board and commission members, even though unfortunately y'all are not paid like other employees. So that does apply to you as well when it says employee. All right, limited exceptions. So there are some things that you can accept. awards of trifling value, publicly presented in recognition of public service, gifts unrelated to your position as a Metro employee or board or commission member. Of course, you can still get gifts from your friends and stuff like that. Meals, beverages, food, promotional items, or hand-produced items of a value up to $25 from a single source in a calendar year. So when we talk about something like, what's trifling value, basically $25 or less in value is kind of what we're looking for in terms of little gifts that people give you or, snacks or meals that they treat you to. And again, that's like from one source in a whole calendar year. So that's not just on one occasion. I have that actually was edited from a prior version, which actually did not include the hand-produced items. So the only thing that you could do was have food up to $25. And I remember at some point, a council member at the beginning of a council meeting was accepting a hat from a constituent. And one of the other Metro legal attorneys at the time leaned over to me and said, "That's fine, as long as he eats the hat." So now you don't have to eat the hat. You can actually wear the hat. And then the last one is free or discounted admissions tickets or access to events or travel expenses from any single source of an aggregate value in excess of $100 if the event is in any calendar year of up to $100 or tickets of face value in excess of $100 if the event is generally recognized as an annual fundraising benefit sponsored by a nonprofit organization. So it's kind of two different things. This one comes up pretty often with like actual employees, if they're invited to present at a conference or attend a conference, and the conference giver offers to, give them free admission or pay for their travel there, something like that. We always want y'all to, if you think you're being solicited for something like that, because you are a commissioner, check in with us. Erica or I will always be available to take phone calls and answer individual questions about any of these issues. But also, like if there's a nonprofit fundraiser, you can accept tickets with a face value of more than $100 for that. And in terms of the process, I don't think, this does come up. This has happened to other people's boards and commissions, but I've been working for Metro for like 16 and a half years, and I don't think I have ever had any of my board and commission members actually receive a complaint from the Board of Ethical Conduct, which I'm sure is entirely due to my excellent advice. But so this is rare, so don't be too worried about it, but it does happen. So people may file complaints under 2222040 with the Board of Ethical Conduct, which is like a separate board or commission that's assembled specifically for the purpose of addressing ethics violations. And another thing that's kind of useful, that again, I've never had it come up, but I thought, that could be helpful, is that you also have the right as a member of a board or commission to request an advisory opinion from the Board of Ethical Conduct if you ever get a tricky question and Metro Legal can't adequately answer it for you, you want a little extra insurance, that's an option. So the ethics complaint procedures, basically what happens is they're made in writing to the Board of Ethical Conduct. Another attorney in my office who staffs that board will investigate, evaluate, and make a report to that board regarding whether the facts, if proven true, would amount to an ethics violation. And then the board decides whether the hearing is substantive, whether the matter is substantive enough to hold a hearing. And then if a hearing is held, parties are given an opportunity to present their case. So kind of standard due process kind of stuff. The penalties for violations, thank you. They're, again, not something to really worry about because I don't see this happen very often or at all, really. But it does happen to It has happened to other people within Metro from time to time. The Board of Ethical Conduct can recommend to the Metro Council that the person who is believed to have committed the ethics violation should be censured. They could recommend that the person resign his or her position, They could refer the matter to a district attorney general if they think it rises to a state or criminal law violation, or they could refer the matter to the director of law, to our boss, requesting that civil action be initiated for restitution or other relief. So again, like, haven't really had this come up. Those are theoretically possible. Another goal we have with this training is to help you understand when you may be biased or have a conflict of interest and should recuse yourself. You do have a duty of independence. You can't act based on your own self-interest, based on a bias against or in favor of people you know personally, or based on the interests of the director or contractors with whom your board interacts. So you must be impartial and act based on the law and evidence presented to you. So that's just very important. You know, like some situations that come before you, you're almost in a judicial role. And it's important that you approach that role from an objective position. And so, you know, again, Erica and I are always happy to talk through any potential conflicts of interest that any of y'all might have. Just feel free to call us directly in the legal department. Our phone numbers are online on the legal department webpage. So that you can contact us. You know, if anyone has any questions about whether they have any kind of conflict or anything like that, please just, you know, reach out. We'd be glad to talk it through with you. So again, when we look at those conflicts and when you actually do have to recuse yourself, whether there is like a financial or pecuniary interest that you have that is implicated is kind of a key part of the analysis, because that's just, you know, I guess more clear to citizens that that's like, you know, potentially, you know, a compromised objectivity. And you're biased or prejudiced for, if you're biased and prejudiced for any party, either as an individual member or as a group. For example, if you're close business friends or business partners with someone who's appearing before the commission to have a matter resolved. And if for whatever reason you just feel like you cannot fairly or impartially weigh the evidence because you feel like you have a strong feeling about what the factual issues already are. So you don't have to recuse yourself if you will not gain or lose any money fairly directly from the decision. So usually if there's not a financial or pecuniary interest at issue, and that can be not just for you directly, it can be for a family member or your employer as well, then you do not have to recuse yourself. And you can, if you believe you can be objective and do not believe that your participation will create an appearance of impropriety. So that's language we use as well, appearance of impropriety. It means like even in a situation where technically there's not a violation, but like it could kind of be, appear to be improper to you know, the citizenry, then we always kind of want to err on the side of looking as above board and transparent as possible. So we would prefer recusals in those situations. Another possible way in which you could maybe be biased in the context of determining a matter before you as a commissioner is if you have outside knowledge from outside the meeting. We do absolutely have people who do this to our commissioners, I think on a regular basis. They try to lobby you, are aware of issues coming up on the agenda, and may email you or contact you directly about it with their opinion. A lot of times that's actually okay. One thing to make it always okay is just to disclose it. Like when you come to the next meeting and the decision comes up before, you can say, I just want to let you know that Joan Smith called me about this, and you know, she told me her position on it, and I feel like I can still be objective, but I just wanted to disclose that I had that conversation with her. You know, then you're fine. There are some instances, and this is very rare for this particular board, where you actually are acting in a judicial capacity, like I told you before. I believe the only thing that we do that with, y'all correct me if I've got this wrong, but I believe the only thing that we do that with is with street vendors who are having their vending license revoked. for some kind of disciplinary infraction. This is really unusual. There was a guy who used to kind of break the rules and sell water when he was not supposed to, who appeared before this commission a couple of times in connection with that. So in that situation, it would actually be improper for you all to have what is called in the judicial context ex parte communication with any of the parties to the matter. So it can be necessary for you to be more objective. Like most of the matters that come before you, you all are sort of like more in a rulemaking capacity, which is more like administrative and legislative. And so in that capacity, you know, legislators are lobbied. That is part of the process. So in that context, it's fine, but just like I said, just try to disclose it and for sure you'll be okay. All right. This is more like to try to make the appeals bulletproof item. So just kind of try to be aware when you are deciding a matter, like what the relevant guidelines and laws are that apply to that. If you have any doubts, definitely raise your hand and ask a question. We're happy to fill that in. And then you want to listen to the evidence that was actually presented before you. We usually always have public hearings and allow members of the public to testify about the various matters that come before you. So you want to base decisions that you make on specific, factual findings that you can make based on the evidence that you have before you, and that testimony or, documentary evidence or, whatever is submitted before you. And studies by experts or firsthand observations of experience with the public, those are examples of types of evidence that it would be fine for you to rely on. Now, unacceptable reasons, unfortunately, sometimes someone has just a really heartbreaking sob story and you just really want to help them out because you're a human being, and unfortunately, you're not supposed to do that. Sympathy for the applicant or for people who are opposed to the approval is not really supposed to be a basis for your decision. An opposition that is not based on the relevant guidelines or laws that your commission addresses, in the example given, this project may be noisy, traffic is actually relevant to you all. So that example is, like I said, we use these with all our boards and commissions. So that the increase in traffic actually would be relevant to you all, but the noise wouldn't necessarily be. The things that you all are kind of charged with by the charter with caring about is the safety of motorists and pedestrians and other users of the public rights of way and the flow of traffic on those rights of way. So those are your areas where you're concerned, and it's not like aesthetics or, some other thing that some other department might have concerns about. With regards to the Open Meetings Act, going back to the application of that act, yes, this commission absolutely is subject to that act. It's codified in Tennessee Code Annotated 844-101 at SEC. One of the things, I think it might be in 844-102, that they advise is that you refrain from engaging in what's called electronic deliberation. And electronic deliberation is, I think if you all email each other about a substantive matter that you may have to take a vote on, that can be electronic communication in violation of the Public Records Act. So that's something to be really careful about. And what I would say, what I generally advise people to do with regard to that is, like, when you get an email with all the members of the commissions on it, refrain from hitting reply to all. Though it's usually an unimportant or procedural issue, like scheduling or something like that, it's still just, I think, better to err on the side of caution and just respond to staff, respond to Andrew or Brad or whoever, that you may be having reach out to you instead of responding to the other commission members by email. And of course, that would apply to like text or other forms of communication as well. And the worst thing that can happen to you if you're determined to have violated the Open Meetings Act is that the worst thing that can happen to Metro, if we're determined to have violated the Open Meetings Act, is that you can be made to kind of redo it in public, like rehab that deliberation and, you know, see if the vote goes the same way this time in that public context. Like in terms of how it could impact you personally, we have had this come up before. You'll see the Johnston versus Metro government case cited there at the bottom. We've had board and commission members have to be deposed about whether they violated the Open Meetings Act, and I'm sure none of y'all want to go through that, so that, like, just to avoid that electronic deliberation. Interestingly, I have had it come up that you can exchange a snail mail written communication with each other, and I think this is partly like out of date thinking in terms of technology, that people think of a letter as an actual public record and an email is like more transient or something like that and like more immediate. And so, you know, the emails are also public records. That is very clear. And so we want to be careful about what we put in emails as well. This is sort of the general duty to vote. We encourage every board or commission who has an opinion on a question to express it by his or her vote. Tennessee law disfavors abstentions. That doesn't mean that you can't ever do them. But basically, you know, if you do it, it's kind of like whichever side has the majority without your vote is definitely going to win, so you're basically helping that side. And board members who abstain because they do not believe the law is correct are in essence legislating. I think I actually have had that come up once with another board or commission, not this one, but generally that doesn't come up either. And abstaining to let the courts decide is also impermissible because it defeats the purpose of having an administrative body make an initial review. So when you are making it, it's kind of part of exhausting your administrative remedies. You know, people have to come before you, they have to get a decision from you. They can then appeal that by writ of cert to the circuit or chancery court, but they are supposed to go through that process. And one thing that is helpful is that the standard that you all have to follow in terms of appeals is pretty low. It's actually that you have to have more than a scintilla of evidence to support your decision, and you cannot be arbitrary and capricious. So that's, you know, even lower than preponderance of the evidence, really. But at the same time, we've still lost under that standard a couple of times. So if you can, you know, articulate those good reasons for your decisions, that's always helpful. Another question that comes up sometimes is when two or more of the commissioners get together, is that actually a meeting that meets the definition of a meeting as used in the Open Meetings Act? The important requirement that adequate notice must be given for all public meetings, such as the council member was referencing at the beginning of the meeting. We want to notice informed parties to give them an opportunity to be heard and to prepare for and anticipate the meeting, whether they live on Preston or Pettus. And Tennessee courts have also determined that adequate public notice is sufficient notice under the circumstances. So that's a nice, super vague standard. There's certainly a variety of different cases showing you like what's enough notice and what's not enough notice. But certainly, I think over a week is almost always going to be above board. Less than that may be justified by certain circumstances if there's some emergency aspect like that. But there's not like a specific number of days that's required by the law anywhere. And then there are some things that actually don't meet the definition of a meeting. If you can go on, yeah, that one. An on-site inspection, if you were to need to like go somewhere as a group and like see like, you know, a physical street or situation. Usually we have the lovely slides that staff provides you with, so it's not necessary to do that. But if in theory you ever had to do that, that would not necessarily be a meeting because you wouldn't be deliberating or voting. If you run into each other and have a chance meeting, that's fine. Just try not to talk about stuff that may substantively come up before y'all for a vote. I don't know what an informal assemblage is, or even if that's how you pronounce assemblage, but I like to pronounce it that way. The attorney-client executive sessions, this will happen occasionally. Usually you don't want them to happen. I'm assuming it's like assembly, but like, I don't know. Assemblage, okay, fine. I kind of like the Frenchy pronunciation better, but the executive sessions, you usually don't want to be in that position because usually that means you're being sued. Like as a commission, you can be sued as an entity, or occasionally they do name individual commission members in lawsuits, but generally my office will provide you with a defense in those situations. And in that case, we may have to have an attorney-client executive session where we talk to you about the litigation. And generally what that'll be is like us, the legal department, making a presentation to you and allowing you to ask questions to us. But again, that should not devolve into deliberating with each other. And the deliberation and vote on that issue must be made outside of the executive session in the context of the public meeting. All right, going on to slide 19. And this is, you know, just general best practices that I think your staff probably already does. They provide a detailed agenda for you, ideally a week before the meeting. So again, the public can be informed and that you have time to look things over. They can provide a staff report or recommendation for each agenda item with the reasoning behind it. And they can start each meeting with a declaration by any board members of conflicts or recusals on agenda items. So like at the very beginning of the meeting, if you have a conflict or something you want to recuse yourself on for some other reason, it's better to announce that right up front as opposed to waiting until that issue comes up on the agenda. And then let's see, best practices for board members: make sure you understand the work of the department, meet the leadership, ask for a tour, you know, whatever you need in order to understand like how the Nashville Department of Transportation and Multimodal Infrastructure supports the work of this commission. Before each meeting, review the agenda and the relevant documents. Of course, just be prepared. The last one, consider adopting metrics for your board to measure whether you are acting timely or in accordance with your board's duties. All boards and commissions have like their own rules of procedures, as does this one. So I think if you wanted to set timeframes for yourself, I mean, you're not a body that really like takes things under deliberation. You pretty much vote on things immediately, so I don't think that's too pertinent to you. But anyway, that is something that's pertinent to other boards and commissions sometimes. But that's it. My last slide is just, do you have any questions for me? Thank you for listening. Sorry, it was a little repetitive and dull.
No, it's very appropriate and really appreciate that. Could you speak on how to approach the media? Or is there any procedures or protocol around media requests to commissioners?
So I would say, that's a great question, first of all. I would say if there is a dispute or litigation actually pending about the matter, you might want to defer to the lawyers. If not, though, I mean, there's certainly nothing that prevents you from making statements to the media. You have that freedom of speech. I would say that might be a situation where, when we were talking about earlier, like if you have some outside contact about an issue that comes up, you should disclose it before you vote on it. So I think that would be a situation where it would be best practice to disclose to the media that you have, or to the other commissioners, that you have spoken to the media about this issue. Given the nature of the media, they may know that already, but it's good to get that on the record. But No, I don't think there's anything that prevents you from doing that. I would just kind of caution you to be careful. I see it more in the context of legal issues. I think they're more often misunderstood than characterized correctly. But on other issues, I don't know to what degree that is the case.
What's an appropriate way to disclose? Would that just be an email to the group or to you, or?
So again, we don't want to do the emails to the group so much because that can be
Sure.
in the realm of electronic deliberation. So I think you do it orally in public at the meeting, when that item comes up. Just, say so-and-so journalist contacted me about this matter and I had a discussion with them. I still feel like I can be perfectly objective on this matter, but I just wanted to let y'all know that conversation occurred, that kind of thing.
Great. Any questions?
The only exception I would have to that, again, super rare, that situation where you actually have the disciplinary matter, like the sidewalk vendors that actually come before you to see if they have committed enough violations that they should actually lose their sidewalk vending permit. Those, I think you might want to avoid speaking to the media about because that's where the kind of no ex parte contact requirement applies. And so I would just avoid talking to anyone about those.
Great. Any other questions from anybody on the commission? Mr. Gibbs.
Is there any type of a media relations? Is there any type of a media relations office or officer that would be a clearinghouse for?
I'm going to let Mr. Freeze speak to that.
As he's coming up, in the past, I believe there's an email address, but
There is. We do have a point of contact. We have a public information officer with the Nashville DOT that we can work with. If you have any questions or if you want to direct something to the department, if you want to direct the media to the department, we can provide you that contact information.
I think in the past, generally, directing it to NDOT has been a good approach. But there again, it's, everyone's free and able to speak their mind as they will, or so choose. Any other questions? Go ahead.
If we wanted to add like an item in the agenda to just ask if there's bias or conflicts, is that something we could do through our rules, or is that something the chair can just do?
I'm not entirely sure I'm following what you're
So you had said,
proposing.
if you do have a conflict, you should approach it at the beginning of the meeting. Could we just have that as an agenda item to ask
Oh, sure,
the
sure,
board
sure,
if that's there, so
sure.
that way we
Yeah,
have
that
pause
could be added
remember
to
it?
the agenda. I'm sure staff could do that. Just kind of like a pause and an opportunity for anybody to speak up if they do feel like they have something to disclose or a conflict where they need to recuse themselves. That's a good idea.
We just add that to the meeting notes and I'm just looking at where that would fall, maybe just before we roll into the consent agenda, may be appropriate time to ask that question in the future, but I would defer to NDOT and legal to deem where that would be appropriate in the.
I would think you might want to capture that in item 2.0 when you approve the agenda.
I think that makes sense too.
Okay. Great dialogue. Again, appreciate the time and the details in putting that together. Very valuable. Thank you. So we'll move on to item 6.2, approval of Demumbrium Hill bikeway improvements requested by NDOT. So item 6.2.1 through 6.2.5 are all tied together in the sense that the work is for the bikeway improvements at the Demumbrium Hill. I will move forward to let Ms. Demon speak to the matter, and then we will have open questions to the commission for any questions on this agenda item, and then move from there.
Thank you. Anna Dearman, walking and biking manager, NDOT. Did not realize until this moment how close my last name is to Demumbrian and Demon, so thank you for pointing that out. 10 years, and I did not realize that until this moment. We're really excited about this project. It's under construction right now. So a few elements we'd like to ask permission from the Traffic and Parking Commission. Item 6.1, and let me pull up the slide you just had. I'll just go in order and give a quick explanation, and then if you'd like to discuss any of these items in more detail, we can go back through. Okay, so item 6.1, we would like to reduce the posted speed limit on Demumbrian Hill from 30, it's currently 30 miles an hour, to 25 miles an hour. And that's consistent with the Connect Downtown recommendations to review speed limits throughout downtown and in the corridors extending outside of the interstate loop, like Demumbrian, which extends just outside of that interstate loop. And it's also consistent with our Vision Zero goals of improving safety and mobility for people of all ages and abilities, using all modes of transportation, so slower speeds will make it safer on Demumbrian for people biking as well as for people driving. Demumbrian is on our high injury network, and so lower speeds will improve safety on this corridor that has seen some serious injury and fatal crashes, specifically involving people walking. To that end, we are also proposing a new pedestrian signal. So this is a pedestrian hybrid beacon. It is a flashing light that, when activated by the pedestrian, will stop traffic, will stop people driving. So it's not like your typical traffic signal that works at all times. It will only flash when people activate the button. So it will be located halfway down the corridor between 14th Ave and 16th Ave. There is an existing mid-block crossing at that location, which has been the site of pedestrian fatalities. And so this will provide the proper, safe pedestrian crossing at that location. Item 6.2.3, we're proposing to remove the existing curbside parking spaces on Demumbrian because those spaces will not be accessible any longer because there will be a protected bike lane on Demumbrian. And item 6.2.5, we're proposing to essentially relocate those paid parking spaces to Music Row. This is a recommendation from the Music Row Vision Plan that just has not been implemented yet. So those two items are really associated. And then I'll jump back to item 6.2.4. We're proposing, we understand that there is a need for on-street loading on Demumbrian. The alley north of Demumbrian is very old and not as accessible as other locations. And some of the curbside uses adjacent to Demumbrian really need on-street loading. And so we are proposing loading areas just east of the roundabout. Those loading areas are possible because we are going to be reconfiguring the roundabout. Currently, it's designed for 2 lanes, and we're redesigning it for just 1 lane. Because of that, we have to reduce the number of lanes on Demumbrian from 2 to 1 approaching the roundabout. And so that gives us the space for the on-street loading zones between the bike lane and the driving lane. Are there any questions about any of these elements? And Corby, I'm sorry I didn't grab the clicker, but we could scoot down to the image of the loading zones. Just up 1. There we go. So that's the loading zone. This is on Demumbrian headed west, approaching the roundabout. Are there any questions on any of the items?
Commissioners, do we have any questions? If not, does that conclude
Yes, that's all that I had to present today. I will note, we'll be coming back to the commission to request permission for a couple more loading zones that are associated with the roundabout reconfiguration.
Okay. Questions?
I mean, I'm very excited about this project. I know it's come a long way. Is there no other public comments for this one today? I know there was some contention to get to this point, but is anybody else in the crowd here to speak on it, or?
There's not anybody on the agenda for this item. And we opened up the public comment section early on, so I would assume no. Yes.
Just want to echo that I'm pretty excited as somebody who rides my bike through this roundabout, like waving my arms in the air, like, please don't hit me and kill me. I think this is going to be really great. And I know it was a long time coming and a lot of stops and starts, and I just appreciate all the hard work and thought that you put into this.
Thank you all.
With that, I'll open up for a motion on the item. We have a second? Second. Any questions?
Can you just clarify if the motion includes 621 through 625?
Yeah. So I would move to approve 621 through 625.
It's been first and second. Are there any questions on the motion? All those in favor say aye.
Aye.
Any opposed? It is passed. Thank you for your time
Thank you.
and your presentation. And that R was hidden beside the M, so my apologies. That was on purpose. Item 6.3, again, we are going to look at these all together, correct, as one. Authorization for new paid parking co-located with existing loading or permit zones requested by NDOT. And Mr. Mateus, you will be going over each one of these, correct?
We don't have to. I mean, I can just briefly explain that these currently are already timed for whatever it is noted here.
Right.
And we are just seeking to get them to become paid parking outside of those hours.
Are there any of these that commissioners need to identify that want to be potentially pulled out, or do we want to go over these individually?
Can we ask questions and then
Absolutely.
vote on it as a whole?
So let's let Mr. Mateus go over them, and then we'll open up the floor for questions as a whole. Does that
Okay.
work?
Mm-hmm. So the Gay Street connector is the first one, 631, on the west side of First Avenue. It's effective 6 p.m. to 6 a.m. Monday through Friday, and all day weekends. This is for 39 spaces currently designated for permit parking only. The other side, right across the street, is already paid parking, so this is just in alignment with the other side of the road and would become paid parking after hours of 6 p.m. I'm sorry, 6 p.m. to 6 a.m., so outside of those hours. I apologize.
Any questions from commissioners?
That was the one I did have a quick question on. What permit parking is there?
It's for the courthouse employees, I believe. They park there. They have designated permits to park within that side. And so we've been issuing those permits for them, and they usually come in at around 6 a.m. and leave around 4:30 or so, but the signage designates 6 p.m. So outside of those hours, we would enforce if this gets approved.
They don't normally, isn't there a huge garage right there too?
There is. I'm not privy to the nature of the approval for the permits because this is something that I historically took on. I don't really know when the permits came about, but if Mr. Brad would like to speak to it, he can.
Yes, those spaces are for jury parking. So easy, quick in and out access is what, that's been there for many years. We've provided a permit for this parking.
Thank you for the question.
Any other questions? Go ahead, Commissioner Gibbs.
What happens if there's deliberation that runs past the 6 o'clock time period?
I'm sorry.
Something that keeps people in court or at that building past 6 o'clock that were normally designated to be able to be there?
That's a very good question, and I mean, we are sensitive to the nature of the permits on that side, so I think we would take that into consideration before we took any action. And we have channels to communicate with the courthouse and some of the contacts that would be able to confirm if they have something going on, there would be an event or something that takes longer than usual, so we would take that into consideration as well.
Thank you.
Of course.
Any other questions? I would ask for a motion on authorization for new paid parking co-located with existing loading and permanent zones, including 6.3.1 through 6.3.7. Do we have a motion?
So motion.
Do we have a second?
Second.
It has been first and second. Any questions or comments on the motion?
Is that, we're not gonna get anything else on any of the other ones? It's just the one we were gonna talk through?
So we're voting for them all, for 6.3.1 through 6.3.7. We asked for questions around them all. Mr. Mateus, if we have questions about any other ones, or if there's more that you need to explain, we can. Is there more information that you would like to present?
I mean, not specifically. These are all just currently loading zones. They're not being utilized outside of those hours, so we would like to make them pay parking to accommodate the public and have options.
And the paid parking outside of the time that it's designated for anything else, it's 24/7 for all of these, right?
Correct. And it would be $225 as per the downtown approved rate.
Any other questions on the motion? All in favor, say aye.
Aye.
Any opposed? It is passed. Thank you, Mr. Mateus. We'll move on to 6.4, removal of Valet Lane at 2000 Belcourt Avenue, requested by NDOT.
I need to recuse myself from this item, please, from discussion.
Thank you.
So this is a existing valet lane that is unfortunately placed in an area of an intersection which would have not been approved under current circumstances. Unfortunately, it was approved in the past. And as such, we are asking for this valet lane to be removed because it's a safety hazard to public. It creates a situation where drivers coming from the 20th Avenue joining onto Belcourt Avenue have limited space due to the width of Belcourt Avenue itself. The valet lane is also not only an intersection, but also if we were to move it to where it would be 30 feet from the intersection, which it's supposed to be by code, it wouldn't allow for any valet space. So it's just unfortunately in a bad spot, and we are not able to accommodate for these spaces to be placed further down because they would be in front of a house, a residency. And so as such, we are asking for this to be removed as a whole.
Thank you. There's a representative from PMC on the sign-in sheet to speak to this item. Would you like to come forward? Please state your name for the record and provide comment.
You guys hear me? Well, you guys probably know me because this is becoming a monthly ritual as we have these valet lanes removed, coming in and defending why we should keep them. So this is, as Emmy pointed out, a valet zone that was approved previously by NDOT. And I think we're having a lot of trouble, just for everybody on this commission, understanding when a valet zone is approved, knowing a month from now, 3 months from now, 6 months from now, will we continue to be able to operate there? The phrase arbitrary and capricious was used earlier, and it seems like it would apply to the maintenance of these valet zones. In this case, I think safety is being cited as the reason for removal, and I would just point out that there has never been any kind of safety problem. We've never had a claim or accident of any kind in the operation. And so, while we understand the need for proactive safety, we're not really, we're biased, but I have yet to hear a coherent argument as to why this zone is unsafe. Last month, we had a valet zone revoked for the same reason, that it was unsafe, but no reasons for the lack of safety were provided. So I think we would just ask for a more cogent explanation as to, what constitutes a safe versus unsafe valet zone.
Thank you for your comments. Any questions or comments from the commissioners? Councilwoman?
Thank you so much. We did talk about this area just a month. Is that just a month ago? It feels like it was maybe 3 months ago.
Yeah.
A few months. Okay, a few months. I was like, it wasn't last month, was it? And there was a lot of discussion. I think I would just point out that in the agenda analysis, the code section that NDOT is relying on is very clear. And so while I think there may have been some exceptions made to this one dates back to 2006, I would just point out that I don't think it's not clear. The standards are clear that it can't be within an intersection. There is crash data here. And while that may not be the valet company's crash data, that is congestion that is contributing to it. And so, I would also just note, I think this was originally approved in 2006 and has just kind of kept going, but I know for sure it has not been in continuous operation as well. So there's no kind of claim that I think it has any right to continue either, given how operations have been stop and start. I mean, since 2006, I would like to guess how many restaurants have been in this building, but that would, it would be many. It would be many restaurants since 2006 in this building, including empty times. And so while I understand that this is your business and I am sympathetic to that, it is not unclear. And it's really, really important that we prioritize safety. We haven't always done that, and it's gonna be really, really hard as we go forward and do that. So I appreciate the staff taking the time to look at these hard ones. I would like to continue these conversations with you to try to find out places where there might be more appropriate valets, but to say that it's not clear, I think is misleading and not accurate.
Thank you. Go ahead, Commissioner.
Staff, you mentioned that you can't move it because there's residential in that area?
Yeah, so there, by code, we're supposed to provide 2 valet spaces for any valet application at minimum. This one only allows for 1, with the other one being in front of a different building. And, as per code also, the valet should be in front of the business. So as soon as it would deviate and move to the right, it would not be in front of the business, and as such, there's also, question of the crosswalk. I don't remember, is there a fire hydrant there as well?
Yes, there's
So
a fire hydrant there.
So it's just, the whole design is unfortunate, and, under current circumstances, it would have never gotten approved. And I want to also mention that we always try to and strive on working with all companies, including PMC, such as the Union Street was one of those examples where we try to accommodate if we were to cancel or move a valet operation to relocate it somewhere else. We put all the efforts forward to these kind of conversations, but in some cases it's just not possible. And this is one of those cases. And lastly, I want to make it clear that there's really only 4 reasons why a valet would be canceled. One of them is not providing valet service in the valet zone. Second one will be amendment. Third one is public safety. And fourth one is 4 times of violating the code. And, it's only 4 reasons, and this one fulfills 2 of those. So as much as we would like to accommodate and help, in this case, we can't really do much.
Appreciate that. Go ahead.
Yeah, I mean, I would just, Obviously, where this valet lane is proposed now it's a safety issue. It shouldn't have been approved. It's a shame that it's stuck around for so long. It does look like there's an opportunity maybe to go down the street and knock on some neighbors and ask if you could put a valet lane in front of that as an opportunity to kind of work with the people around you to kind of move it out of the intersection. But yeah, I mean, it being there, I think we had multiple incidents that were identified in the staff report. So I absolutely would be fine with removing this one.
Thank you. Any other comments from commissioners? If not, I will ask for a motion on item 6.4. We have a second.
Second.
It has been first and second. Are there any questions or comments on the motion? If not, all in favor say aye.
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 Any opposed? It is passed. Thank you. Item 6.5, removal of valet lane in 1904 Broadway, requested by NDOT. Mr. Mateus.
Yes, sir. So this setup in the past was a two-lane a flow of traffic that unfortunately turned into one lane, and now the valet lane itself is in a lane of traffic. And as such, we have to recommend for it to be removed due to the nature of it being an incomplete violation of safety, as there's no other way to move or approach the road except for that lane itself. So as such, we would like to, as NDOT, propose for this removal. Unfortunately, again, it's PMC, but public safety and public hazard, so.
Great. Any questions from commissioners on this item?
I do have one. The report that we had, it said that this was originally a loading zone.
That could have preceded it becoming a valet zone, and I don't know exactly when this occurred. It might have been throughout the previous administration, parking administration, but at this point, and also at that time, it was a two-lane street, so it made sense that they approved it. It's just at this time, it's one lane of traffic, and there's just no room for a valet to be any longer, regardless of the fact that it's if it would be a loading zone today, that would have been revoked as well, or asked for it to be revoked, because there's just no space in a lane of traffic.
Okay,
I can speak to that. The traffic schedule right now says that there was a loading zone approved at this location. What I think is in that photo to the right where you see the little pedestrian sign, and behind it says valet parking only. I'll bet when I pull that sign down, if I pull that off, there's going to be a loading zone sign underneath it. I think that it was converted into a valet zone and not necessarily approved by this body at some point years ago.
So that was where I was trying to get to. If that's the case, if this is an approved loading zone and not an approved valet zone, if we don't have any understanding that this is a valet lane that's been approved by us, should we be removing this as a loading zone?
Just to err on the side of caution, I would suggest to you form the motion as removing both the valet zone and the loading zone.
I think
And
the
authorize
commissioners.
no parking at this location.
And authorize no parking at this location. Thank you, Mr. Smith.
I guess procedurally, just to piggyback off what, is there a valet lane currently approved there? Am I following what you're putting down, Neil?
Yeah, and I mean, I would imagine if there is a valet lane, there was a valet permit at some point as well.
So if there was I'm sorry, I don't have the document on me to confirm, but what I can tell you is that if there was one, there's a charge for it, and by revocation, the charge goes away. So this just becomes a right-of-way street, a road.
The valet that was, if it was operated there years ago, was impacted by a prolonged period of construction. Vanderbilt had undergone some adjacent construction. That side of the road has been closed down for a lengthy period of time. It's since been milled, resurfaced, and restriped, and now you can see it in its current form. So the business that was involved there hasn't run a valet there for quite some time. We could consider it an abandoned valet zone.
So is it appropriate to vote on the removal of a valet
Just for
lane?
the sake of clarity, I think, go ahead and vote, like the 3 points that we made previously. Remove the loading zone, remove any valet zone, and designate it as no parking.
Any other questions or comments from commissioners? Yes, Councilwoman.
Just a general comment for the area. There's just a lot of illegal loading and unloading that goes on in the middle of this stretch, kind of all the way up, as y'all I'm sure know. And I'm just curious, is NDOT kind of looking at where might be appropriate loading and unloading zones through here to kind of corral folks into the right places?
We do these regularly throughout our drive-arounds or drive-throughs of the city. We identify some of the curb space that is available to be turned into a loading zone. I'll specifically look into this now that you mentioned this, and we can get back to you with that if you'd like.
Thank you.
Thank you.
Any other questions or comments?
Yeah, I know we had a recent example of a valet lane that just kind of happened to be there with its own signage. It would be fantastic if there was, a better GIS map of where valet zones are, so that way we can try to see where they are and have a better understanding of if we're all on the same page that it's supposed to be there.
This is Brad Freeze with NDOT. That's a good point. And we are actually looking at GIS maps for our loading zones throughout downtown area. Actually, we've got some of them specifically in the Connect Downtown scope area. We had GIS drawn and we actually audited all that space, all of our curb space within the Connect Downtown zone. So yes, we are moving to do that entirely through Nashville, Davidson County. That is a good suggestion.
Thank you. With that, any other questions? I will like to request a motion to remove loading zone, valet zone, and no parking at 1905 Broadway. Removal of loading zone, valet zone, and a no parking, and make it no parking at 1904 Broadway. Do we have a motion?
So moved.
Do we have a second?
Second.
It has been first and second. Any questions on the motion? If not, all in favor? Say aye.
Aye.
Any opposed? It is passed. Thank you for your time, Mr.
Thank you.
Mateus. Item 6.6, Smart Loading Zone Pilot. This is just a presentation by Mr. Freeze.
That is correct. Thank you, Chair Mason. So this is really in an effort, you are aware, you've seen some of these presentations before as part of Connect Downtown. We are going to dive a little bit deeper today and share with you what we're talking about when we talk about smart loading and our curb management as a part of Connect Downtown. Oh, thank you. I've just been past the clicker under my armpit there. Thank you. Appreciate it, Kobe. So you've seen these slides before, some of these slides before. Let me see if it'll. All right. There we go. I'll get there eventually, I promise. Here we go. So you've seen these slides before. You've seen the flexible approach that we're taking as far as the curb. You can see the curb uses identified, 4 a.m. to 4 p.m. and then 4 p.m. to 4 a.m. and how we are looking at that with also rideshare locations and identifying what would work best with that, with the different zones downtown. We have done extensive stakeholder engagement with regard to these. So this is one step. Another step is to expand the curb enforcement and use autonomous systems as far as autonomous enforcement, smart loading zone systems for our curb management. So that's what we were going to talk about today. We don't want to sneak up on anyone, and just drop a program out there. We want to have enough time for the public to hear about it, but also for there to be discussion on this by this committee as well. So this presentation today is just a background on the technology that we're proposing to use. And we will actually be sharing more during our next traffic and parking meeting. This committee actually has policy with regard to a smart loading zone policy that was put together years ago as part of Metro Code. So we are going to be proposing to update that policy. So we'll be bringing that policy an update to that policy before you. So in the next meeting, we'll be bringing that before you. So we will be sharing that well ahead of time. We actually plan to send that out to you, the commissioners, and post that online in the next couple of weeks. So you have plenty of time to review that and what we're talking about. But today, I would like to actually invite Kelly Ferguson up here. So Kelly is actually with Automotus. Automotus is a company that we are working with regard to the smart loading zone management system that we're developing. She actually has a presentation sharing some of the best practices from around different cities across the U.S., but also what we're talking about when we talk about this smart loading zone in the city of Nashville.
Thank you, Brad, and thank you to the commission for having me here today. All right, well, my name's Kelly Ferguson. I'm Chief of Staff at Automotus. We're a curb management company, and we're working with cities to help them make safer, more sustainable, and efficient streets for everyone. We utilize cameras and computer vision to help better inform cities on how curbside activity is being done, and we're able to automate certain operations such as smart loading zones, which I'm going to talk more about today. But we also can support cities in terms of bike lane enforcement and other types of enforcement as well. All right, well, I'm sure you are all painfully aware of some of the challenges that city streets are facing today. In particular in Nashville, just your downtown has so much commercial activity, and this is causing a lot of strain on those resources for curbside parking. This results in a lot of double parks and safety hazards, and ultimately can hit pockets and whether it's failed deliveries or parking tickets. And ultimately the solutions that are available curbside right now, be it meters or apps, are not appropriate for loading and have a really low compliance rate. So at Automotus, what we're trying to do to solve this problem is to automate curb management. Again, utilizing cameras and computer vision to help provide data that shows how parking is working in real time. So that can be in the form of what types of vehicles are using the curb, whether it's freight or passenger vehicles, the dwell times that vehicles are parked, any sort of peaks, things like that, so that cities can better align policies with how curbs are actually being used and the types of activity they want to actually see at the curb. We're also able, as I mentioned earlier, to automate curb payments and invoicing. One of the things I know that's really important to many cities is a commitment to privacy, which is a core foundation of what we believe in at Automotus. So some of the ways that we do that, being that we do use cameras, technically we process all our video at the edge, which means that the data that goes to our analytics dashboard is all anonymized. It's metadata, so you'll see the graphs, but you won't see any personalized data. When we are collecting license plates or images of the beginning of a park event or the end of a park event, any sort of faces or non-relevant license plates are all blurred, and we only keep that information as long as it takes either to pay an invoice relating to that park event or depending on the data retention policies that's with the city. We're also very regularly audited by third parties for these practices. So, we're proposing a smart loading zone pilot, really to help make a static piece of infrastructure, the curb, more dynamic, to help support the challenges that help support, build on what Nashville has seen in its Connect Downtown study, so that we can improve turnover, reduce congestion, reduce double parking. So these are some of the areas that we're initially looking at for some of the most problematic loading areas in the downtown area. So what exactly is a smart loading zone? How exactly will it work? Essentially, what that would mean is that loading zones would be a progressive pay by the minute program. And so in these cases, a vehicle would park, and if they're parked for 7 minutes, they would only be charged for 7 minutes. And say the first time a vehicle shows up at a curb, they're at a smart loading zone, they would register to get a curb pass account in which they would have a digital wallet. Then it would be completely automated. It would just be by their license plate. And so if they're there for 37 minutes, they pay for 37 minutes. So only by the minute. And the structure would be progressive, meaning that we're really trying to incentivize that turnover. So the shorter period of time a vehicle is parked, they pay a lower rate. The longer, for chunks of 5 to 10 minutes is higher than 0 to 5 minutes. Going up to an hour, it would be 30 to 60 minutes. That would be the highest rate. So really looking at incentivizing that turnover. The policies can be made flexible so that depending on the time of day, you can adjust rates or policies so that you can try to make shorter dwell times, things like that. So we've been working with a variety of cities to implement different solutions. And in the cases where we've done smart loading zones, we've seen really positive benefits. In particular, we're really proud of the reduction in double parking that we've seen, over 75% reduction, and also a huge reduction in the amount of congestion that we've seen in these cities. So overall, just really positive benefits as these zones are being made more efficient, higher turnover, and that you're seeing a lot fewer of non-commercial activity in these spaces that are meant for commercial activity. Some of the things that we find that are really important when we're implementing these programs to make sure that they're adopted early and are as effective as possible early at the gate is community engagement. I know the city and NDOT's done already a lot of work on that front, but we have worked with local fleets and national fleets in the past to make sure that they're aware of the program to get them signed up early. We've worked with business improvement districts and merchant groups also to help inform and make sure people are as up to date as possible on the programs. In the past, our team has gone out and done door-to-door work and talked to those local businesses to make sure they're informed and that if anyone's doing deliveries to their business, they can help educate those folks as well. And then lastly, we found like a really effective strategy is just making sure that these zones are very well marked and noticeable. In other cities, we've adopted the color purple to showcase the signs and curb delineation. Of course, we'll modify it according to however the city wants it, but we found this to be an effective strategy to make it very noticeable and really encourage that compliance early out the gate. I think that's it. I'm happy to answer any questions that you all may have.
So this is an introduction. So you will be getting an update on the policy as far as what we're talking about further from a payment aspect, but also as part of alignment with our Metro Code. We've spent quite a bit of time already with Metro Legal talking about the Metro Code. So what you will see is based on their review as well. So you'll see that coming before you here within the next few weeks in advance of the next meeting. So in the next meeting, you'll have another opportunity to ask more questions with regard to that program, and we can provide further detail as well. So happy to answer any questions at this point as well.
Yeah, thank you for that information. Any question or comments from the commission?
Yeah, so this looks great. I know in the past, NDOT has done a loading zone pilot before. For the future meeting, it would be great to kind of have a report on how that went, what we've gotten out of that, and then how that relates to this one, which is now a new pilot.
We can, yes, Commissioner, we can draw the comparison to that previous, it was actually before COVID, there was a smart loading zone pilot. It was based on the honor code system. You could actually reserve a space, but there was no enforcement. It was more signage, and then people could use an app to go in and reserve a space, and they would pay for that space ahead of time in there. We'll provide more information as far as how the success or the challenges with that program and successes of that program, but also compare that with what we're talking about now. That's a good suggestion.
I did have a few with regards to some of the cameras, and then with the location of the smart loading pilot area, are we incorporating, I know, our parking management consultant last, Metro Police, and WeGo have some opportunities and some cameras already in place. Can this be integrated together, or would it be independent of those systems?
There is a possibility of integration, but at this time this would be a segmented system during the pilot phase.
How many cameras would have to go up during the pilot?
So we've identified different zones. So it's really, we're focusing first on some of our high traffic areas, like Broadway, for example, is an area that, during certain periods of time, loading is a major disruption as far as the activities along Broadway. So we right now, I can't give you a number right now, but we can give you a number when we come back as far as how many. It's going to start on Broadway as one of our first, and it actually is in alignment with what we're talking about with Connect Downtown. So I can detail you that and the number of cameras that would be involved in this first step.
Just to add to that, typically our cameras can cover between 3 and 5, like 20-foot spaces. So just depending on the viewing angle there and how much we're trying to cover, it would, that's how we come up with a count for where the cameras go.
You mentioned metrics to define problematic loading areas. Broadway is one of those, and what you've identified in this presentation. What other areas have you looked at, or have you looked at any other areas yet that you would like to move to next?
So really all of Connect Downtown, we took that into account when we were looking at these pilot locations. So if you go back, yeah, you can use that. You can see we have, there's high need for loading downtown, but there's also a lot of violations of the loading zones, just people, rideshare parking in them or other things, disrupting those periods of times. So yes, we are identifying, you can see here along 4th Avenue, there's a stretch that we're looking at, including some of the smart loading zone, also along Union Street. So these are all in alignment with the loading areas and the zones that we identified in Connect Downtown. If I go back here to this slide, see if it makes it way, okay. Here you can see where we had identified loading zones with there. So we actually layered this Connect Downtown study in when we were proposing these pilots. So if you look at this, looking at this slide, this is layered against the slide previously that you just saw where you actually had the tentative locations. But we're going to be coming to you with the specific locations, and we'll share with you more information about each location that we're going to be deploying at before we actually move forward with seeking your approval for the deployment.
I see you develop strategies to address autonomous taxis and deliveries. Is there a timeline for that? Has there an approach been discussed?
Yes, we actually, that's a good question. So as you may have heard, there are the possibility of future autonomous taxis in the city of Nashville through a company called Cruise. They were in the media a few years, last year, quite a bit in there. So we are actually moving to do some research in coordination with the University of Middle Tennessee State University, actually looking at different policies and procedures. We actually started a research project for them to help support us identifying best practices from across the other cities, like the city of Austin, the city of Phoenix, the other cities that have these autonomous taxi pilots deployed.
So no timeline, no, just discussions?
No, the research itself is on a 8-month timeline. So, but we will give you an opportunity to see. I think it would be useful for us to come back and present some of that to you as far as the output of that research.
Yeah, that'd be great. Go ahead.
Wasn't there a lot of problem in Los Angeles with these cars?
With Cruise specifically?
Or
autonomous taxis?
Mm-hmm.
There have been, yes, there has been talk about that in different cities as far as incidents occurring. We are have had conversations with crews, and they are, very open and transparent to us as far as talking about possibility, but they have paused operations currently as far as a future pilot in Nashville at this point.
And is that something the legislature can override if we as a city don't want to do that?
There are some limitations. That's a good question as far as as far as state legislation. So there is state legislation that does prevent municipalities from enacting certain laws that would restrict the ability for them to operate completely on city streets. So there are some challenges with regard to that at the state level.
Will this commission be responsible for the licensing of these autonomous taxis and deliveries? Or how would that, has that been thought about?
I can ask Metro Legal that question and maybe to chime in.
Yes, as Mr. Freeze said, there is a state law that to some extent preempts regulation of autonomous vehicles in Tennessee. But I'm not, to the extent we're applying laws to autonomous vehicles that, are just rules of the road that everyone has to follow. Absolutely, we do have the right to enforce all of those. And so I think it may just be a question of, what aspects of it turn out to be problematic once it starts happening, which it hasn't yet, as I
it would be tied to loading and unloading zones and, some
They would have
specific
to follow
areas
all the
within.
rules that
Yeah, they would have to follow
everybody else would have to
the rules of the loading zone if that's what you're talking about.
Absolutely.
They would have to
Yes.
identify specific areas to.
Correct.
Maybe we're going down a rabbit hole, but. just
What about
curious.
pedestrian safety with these things?
Oh, yeah, that is something that has been talked about a lot, as far as the governing board, NHTSA, the National Highway Traffic Safety Administration, actually has been involved in reporting and studying these systems for quite some time. So, yes, they actually issued a report about this not so long ago about this. They do investigations as far as the specific incidents that were involved. So that was why they actually issued a ruling to suspend their operations in some of these cities until they address some of the concerns with regard to that. But yeah, there have been concerns in the past.
And just for clarity here, this slide maximized the curb. Top right, there's a star that says TPC, which I'm assuming is Traffic and Parking Commission implementation role. And then the implementation of autonomous taxis and deliveries has a star beside it. So
Yeah,
understanding that the extent of that
So this is strategies. This was a recommendation from Connect Downtown to develop strategies, nothing to do with implementation, but actually how we are going to be preparing to address that as a city.
Great.
So that's what this specifically addresses, not the deployment of such.
Great.
I would ask legal if this is coming down the road, that commissioners be provided about our own liability if we're supposed to be overseeing pedestrian safety. So I've been reading a lot about what's happening to other cities with this, and so if we're going to do it,
We
if we're
would
coming,
say that
then
you would
we
have
need
this,
to know.
yeah, the same kind of qualified immunity that you would have in making any of your decisions as a part of this commission in this instance, but we can do something more specific on that for you if you want. But yes, you would absolutely have your same qualified immunity.
Okay.
This is not we've been down this a little bit before in the past on other things.
If I may, in terms of your authority, I think that the autonomous taxis and deliveries are something for the future. But I think what's before you now is really the development of regulations to implement the flexible use of the curb through automotives services.
Yeah.
And you do have the authority to adopt regulations about that.
Yeah, we've kind of gone down a little bit of a rabbit hole when we're talking about that. But yes, those are two separate things. Thank you for delineating that, Teresa. What we're talking about as far as smart curb space management really has nothing to do with autonomous taxis. It's more of just how we can autonomously monitor our curb space and manage that.
May I request if something's coming down that we need to approve, can we talk about deleting anything that has to do with autonomous taxis?
Yes.
And deliveries. Thank you.
Yeah, I would just, the clarity around that, and appreciate your presentation, would be appreciated. Any other questions or comments?
How would enforcement be conducted?
How would enforcement with the autonomous curb management system? So it would be enforced through the camera system that actually captures the information and catches the violators in there. And that would be they would first be submitted a charge for the actual being in the actual space. So everyone will be charged to be in that space. If they fail to actually pay for the space, then they would be issued a violation, a citation for parking violation.
Go ahead, Mr. Quinn.
So on that, my question was going to be around Uber's, Lyft's, food delivery that are short, and I guess saying that we would be paying for a couple of minutes. And I didn't register for this. And how is that important?
Yes, can you hear? The system, it would go to the register of that vehicle.
So from your perspective as the person who's been managing this in other cities too, the way I think it understands of, if you're getting charged for something as the driver of this, that doesn't necessarily always get added to the bill of what's being charged. So do you have integration with those companies to kind of add that as the extra fee to be dropped off in this place?
No, not at this time. However, we find that because having access to the curb is such a priority for a lot of, whether it's DoorDash or other, rideshare companies, that the faster access to curbs and pickups and drop-offs and things like that, it really helps make operations more efficient, which actually helps them, have more rides or have more deliveries, things like that. So it actually helps with operational efficiency.
So Automotus, is that how you pronounce it? Automotus is specifically geared towards loading zones, right? And those loading zones, albeit that slide, doesn't really tie back to the autonomous piece or any of that, some of that stuff, right?
No, it is not related to autonomous shuttles or taxi services.
So over the...
The name of the company that we're currently working with is Automotus, so I can see how that could be confusing.
So over the next 8 months, Automotus will be doing research, or the 8-month research is with the autonomous vehicles with NTSU?
Yes, yeah, you got me on it. You got me on a sidetrack here.
Okay, and that's separate.
So,
okay.
I wanted to update you on that since you were talking. We talked about, autonomous taxis and regulating them.
So automotive is just a part of maximizing the curb.
That is correct.
So it's one piece to that.
Mhm.
Okay. Sorry for getting brought into
No, that's okay.
some other stuff, but,
important.
okay. So on the 8-month study, you all are going to provide some feedback to that as it becomes available. And with relation to automotive and the smart loading zone pilot introduction, this is just an intro to some of the information and things that we'll be gathering over what period of time?
So we are actually going to be coming before you in the next commission meeting with the policies. So we're updating the policies of this commission. This commission owns the policy with regard to smart loading zones.
Okay.
So we are updating those, and we'll be sharing those to the commission and to the public. You know, it'll be out on the website as well in there. So that by the next time, there can be questions related to that, but we will look for the commission's approval.
Any other questions or comments related to automotives? I need to change y'all's name. And smart loading zone pilot introduction. Any other questions? Yeah.
I guess one more. I know LPRs from the police perspective that is a conversation that has a lot of discussion in Nashville. How does that relate to what we're trying to do here?
That's a good question. So, per Metro Code, and I can refer to legal here, Metro Code does allow for LPR systems to be used for parking enforcement, non-moving violations like that. So that this is actually why we're able to actually use this technology for this purpose.
That's correct. I think what you're referring to is council or Metro Code provision, section 1308080, which does with some types of surveillance technology require council approval by resolution. In this case, however, we are determining that this comes under subsection 1308080, capital letter H, period, which says, notwithstanding the foregoing, the provisions of this section shall also not apply to the operation of a license plate scanner installed onto or within the public right-of-way that meets the following conditions. The license plate scanner is used solely and exclusively for determining whether a vehicle is violating parking restrictions. And I think loading and parking are basically, it's just one kind of parking, essentially. And the specific vehicle's license plate number shall be deleted within 30 minutes of its exit from a monitored space unless that vehicle is suspected of violating parking restrictions for which enforcement action would be appropriate. So if the person pays, immediately and all above board, we're not going to be keeping the data about their license plate number. That will be deleted. If they don't pay, essentially, then at that point, they can keep the data. They do actually make an effort to just encourage the person to pay, I think, by sending a couple more invoices. And then at some point, we'd kind of draw the conclusion this person does not intend to pay. And then at that point, that information is turned over to NDOT staff, who have the ability to write citations. And they have to do an independent review of the data that was captured and provided by Automotus. And they have to determine that there is probable cause to believe that a violation of the Metro Code occurred. And once they have made that determination, they have the authority to issue a citation. And they have the ability to serve citations by certified mail. So I think that's how that would be done.
So within 30 minutes of a vehicle driving in around that area, your software is going through it and parsing out the other license plates, putting them through, you're charging certain people, but then you're blurring out everything else, and that's done within 30 minutes.
Yeah, it's done automatically. So if there's a count that's attached to the license plate, then that is automatically charged once the vehicle leaves the space. If the vehicle does not have a license plate, then that would trigger an invoice.
Yeah, and I'm talking about, so there's ones that obviously you would be keeping because you're trying to charge them, but then you had said that there's some form of trying to remove other license plates from the image.
Oh, yeah.
And
So, yeah,
And we're able to do that, you have it within 30 minutes.
yes.
Any other questions? We appreciate your time.
Thank you. Thank you for your
Look
time.
forward to follow up.
We'll be back next month.
To this next month. We'll move on to item 7.0, unfinished business, valet fee policy approval. Mr. Mateus, before you get comfortable, I believe we have 3 people from the public that would like to speak. I would like to ask for them to come up and provide comment first, if they wish to. And then we'll move forward with you. Mr. Varshall, are you, or I just don't want you to miss your opportunity. Okay, great. If you don't mind, state your name for the record and prior to speaking.
I think I got the right one there. Yes, good. Lisa LeClaire, I'm the president and CEO for the Greater Nashville Hospitality Association. And let me say that, I've been coming to this meeting for some time now and observing the discussions and how our city is moving forward. And I just want to say it's such an exciting time to live, work, and play in Nashville. Our streets, the policies around them, and our plans really have not kept up with the rapid growth that we have seen all over our city. And so I really thank all of you for your very thoughtful and good questions related to decisions that are going to help guide those policies and procedures. So congratulations. Oh, and Ms. Costonas, do you know all of those items by number? So impressive. All right. So let me just say that on these, as an industry, we are in favor of the new formula to calculate these valet fees. And I have mentioned before, many of you have been on this commission for some time. We feel this is a more fair assessment of the value of the curb compared to the formula that was adopted back in, I think it was 2020, and then implemented in 2022, if I'm not mistaken. So I just want to say thank you for your favorable vote on this moving forward. We appreciate all the consideration, and I think you've asked very thoughtful and good questions.
Thank you.
Eric Schwartz with Metropolis. Yeah, I echo a lot of what Lisa said, as we work very closely together with the Hospitality Association and also with Emmy and NDOT as the fee policy has changed. I think from my perspective, the one thing I would ask is, I know this has been a long, drawn-out process, but whatever is agreed upon or finalized today, we put some timelines and parameters around it going forward. As this changed in 2020, went in effect in 2022. Now we're revisiting it now. And some of these properties you're talking $50,000 to $60,000 valet lane permits. And for it to have swings, $1,000 per lane, per location can have real implications on how a business operates. And then also with the cutouts, and whether it be a lane directly off the street or an actual turn through, what is charged and what is not charged. Would like some kind of stipulations on when we'll revisit that. If it's like a 3-year policy, if it's a percent increase that goes into every single year, all those allow for businesses to better plan and prepare for that.
Thank you. Really appreciate your comment. Mr. Mateus, if you don't mind, now you can get comfortable.
Thank you. and also thank you for the speakers. For the new commissioners, just a quick recap, as they might have mentioned this policy that we're presenting here today with the updates from a couple of months ago and last month is really a revision of the previous policy that was implemented in February of 2021. And that policy took into consideration a value calculation that really didn't reflect reality or the hours of operations for some of the businesses. And what that meant is that the Valley world went from not paying almost anything to paying, incredible amounts of fees annually. And this formula and this Valley fee policy is making it more of a fair policy and calculation to where it is, first of all, in alignment with the curb usage approved rates of $28 and $35 for the districts, and also making sure that it's based on the actual hours of operation. So it's much more transparent. It is, as you could have heard, much easier to understand, and it brings forward a few things that we really need to have as a city or as a Valley operator, as a compliance enforcer on NDOT side, and it just brings all the sides together to where we think that this is going to be something that can have a long-term effect and can be valid until decided otherwise. For the Valley parking policy itself, if you wouldn't mind looking into your pages 1 or 2, there are configurations that are kind of standard for the curb throughout city of Nashville. Configuration 1 is an applicable configuration that results in a loss of curb parking space, as it's shown on the picture. And these are actually reflected and copied from the previous policy, so this didn't change much. The only thing that did change is configuration 3, which per previous ordinance that was passed now in March and approved, became also a configuration that results in loss of curb parking space and therefore would be a charge for it. And then configuration 4 would be, I know it looks a little complicated on the picture, but think about JW, Marriott, that would be the configuration that would be, or maybe DoubleTree. Those are configuration 4, which would mean that part of the cutout would be on private property. Hence the diagram and the picture shown on configuration 4. I don't know, I think this would be best to go in phases, so if there are any questions to this, I'll take them now, and if not, I can proceed.
Just for clarification on this image, the parking just in front of that half circle, that's not always the case. Like, for example, at the JW, there's no parking in front of the.
Correct, yes,
So
it's
this
not
is
always
just
the,
a general
correct.
image.
It's just, it's just an example.
And there's separate driveway fees that you would have to pay to actually create 2 driveways, right?
So the private, yes, so the private part is handled within the confines of the development, and then anything that happens on the right of way, that this is what pertains to it. Okay, previously, in the previous meeting last month, there was a bit of a discussion about what a permit is and what a license is. So we did include this here for transparency purposes. And just to recap, there are 2 types of things that a Valley operator needs to have to be able to operate within the city of Nashville. One of them is a license to be an operator, a Valley operator. And the second one is an individual permit per each location that they would need to obtain to be able to legally operate as a Valley operator. They are mentioned in the code 1241. I believe outside of 1241-020, which pertains specifically only to the license, everything else pertains to the permits. It's not a long read, but I'll be happy to answer any questions. There are criteria specifically for the license, and there are criteria for the permits. It's outlined here in the Valley policy as well. And following that, I would just want to proceed with the fees, unless there are any questions about the statements that I just made.
No, appreciate you helping us.
Thank
Get
you.
A little clearer.
Thank you. And I also want to thank you for guiding us on improving this policy, because I really do think this is the best one that we've had so far. So thank you for your comments from the previous meetings. As far as the fees, there is a signage installation fee that, as per code, has not been implemented in the past. It is implemented now. We would have, for purposes of compliance and submission on a timely matter, we have a cutoff date of October 15th for renewals and also new applications. And just a reminder again, because I believe this also came up, any applicant can apply at any time throughout the year, but the permit and the license both expire end of calendar year. So it's a renewal annually for both. What we ask as part of this policy is for the valley operators, such as the ones that we're sitting up here in front of you, is to be able to submit the paperwork by October 15th so that we can invoice by end of November, ideally. And this is always for the following year. We implemented some penalties for late submission, which again only applies if somebody is not submitting within a time frame of October 15th. And this escalates to where after November 15th, which is a month after the submission date, they would sit here in front of you and state their case as to why they were not able to submit, and you would have a chance to either revoke a license or just hear out the reasoning and go from there. One of the big parts of the Valley policy also is to make sure that there is no illegal operations of Valley, which is something that we would like to avoid, as you could have noticed in the previously throughout this TMP meeting. We want to avoid, and we want to make it, with all fairness, not easy for Valley operators to be able to operate illegally, and therefore we are implementing some of the penalties for operating without a license that should be felt by the operators, which again only applies if they are, operating within the bounds of the code. And those are outlined here as well. Outside, any questions so far? So lastly, second to last, I'm sorry. The calculation itself, as you can see, is based on the base application fee, the number of approved metered spaces, and then simply whether it is being within the parameters of what we now call central parking district or non-central parking district times the utilization. And I'm going to explain just briefly what this is, because this is a new term that we came up with. So the CPD, or the Central Parking District area, is consistent of downtown, Sobro, Central Business Improvement District, CBID, the Gulch, and the Gulch Business Improvement District. And these rates that you can see in front of you are based on the approved $35 per day per space rate. The non-CPD, which is the non-central parking district, is the areas of Midtown, Edge Hill, Hillsborough Village, Music Row, and Belcourt District. And these are, as per the tiers that we've set up here, also based on a $28 per day per space approved rate. You also requested to be more transparent with the images that we had, or the maps. So we came up with 3 different maps for you so that it would showcase exactly what I just mentioned. If we could scroll down. The first map showcases the downtown area, so that would be the Central Parking District, CPD, again identified as Downtown Sobro Central Business District. And this would be the first picture. That one extends from Dedrick Street to Lear Avenue, and then 1st Avenue to 10th Avenue. The second part of the CPD would be the Gulch, and that would be, we put on a separate picture for transparency purposes. The Gulch and the Gulch Business Improvement District stretches from 11th Avenue to 8th Avenue South and Broadway to Ewing Avenue. And then lastly, the non-CPD, which would be the non-central parking districts, aka anything that is not within the CPD, would be identified but not limited to Edge Hill, Hillsborough Village, Music Row, Midtown, Belcourt. and any new or active applications for valet locations in other neighborhoods that would be outside of the CPD or CPD, but within Davidson County. And so all of the new ones in the future would fall under the CPD, the non-CPD district. Any questions?
I generally don't understand why we need a map for the third one.
Well, it was a point of discussion in the last meeting, so we wanted to make sure that it's here in case a question comes up again.
The reason why I don't understand it, and the reason why I brought it up before, is there's the central parking district that we're now, is that what we're calling it now?
CPD, yes.
And then everything else.
Correct.
And so showing this map, again, I used the example of my own neighborhood that has a valet operator that's not on this map. So it just seems like it adds confusion.
Understood. The purpose of this policy is also in case there is somebody new that comes and becomes a valet operator. I mean, I'm not a Nashville, I wasn't born here, so for me, any information that I get extra is, I always take it with, always take it as something that I can utilize, so I see what you're saying. I don't know if it yields for us to remove it, or I'm not sure if you would like us to change something. I'll gladly do it, but we thought this format would be transparent. Yes, ma'am.
I think the problem comes in that what was confusing last time is that we have downtown and then we have everything else. And the map last time and the way we defined it last time said that it was really just this area, but it's not really just this area, it's everywhere else. And I know several of us requested to get draft copies before the agenda was filed. That didn't happen, unfortunately, so we were sort of stuck with what was attached to the agenda. And I think I'm still not comfortable with this map because it's misleading, because it says this is the area, but also anything else that's not downtown is in the area. So to me, the map should either not exist or it should be the whole county without the downtown area shaded, which is a map I know we might need, I don't know, planning can, I think Greg Claxton can probably spit that map out in his sleep. NDOT may have that same ability as well. I think, though, my concern is this really needs to get passed and put into place, because every month we delay it is a month we are not collecting these valet fees. So my question is, and I don't know if the board is willing to do this, I think very quickly these changes could be made and we could make a motion to adopt it where instead of identifying these neighborhoods and others, make it anything not in the downtown area and either remove this exhibit or substitute it with one that will be the whole county highlighted minus the downtown area. And I don't know if that's something, so I guess there's a legal question. Can we make those changes very quickly and make that in a motion? And two, is that something that the board would be willing to entertain? Because I agree with my colleague that it's still confusing because it still makes it seem like, are we even charging for valet outside of this area or downtown? Some people are visual people, so they just are going to look at the map and not read the words that make it clear it's everything else. Some people like me aren't even looking at the map, we're just reading it, so I know that it's everywhere else, but I just want to make sure that we're not creating confusion, and I do think that still creates confusion.
Go ahead, Ms. Costones, to answer that question.
You know, if you wanted me to speak to the legal part of that. So absolutely, you all have the rulemaking authority here. Staff has presented with you with a proposed set of regulations. If you wish to form your motion such that you want to approve it on the condition that changes A, B, and C are made, you may do that. And if that motion passes, then the policy would be what you all adopted and not what staff proposed.
Commissioner.
Yeah, I just had one question.
Yes, sir.
Are these areas and the valet permits Like if you have a central valet permit, is that for that area only? You only have, or can your central valet permit be permitted in a non-central valet?
It's both,
It's both.
correct. It's the permit differs. Well, that's what I was going to say. So the permits differ by CPD and non-CPD in the sense that the rates are different. So that's the differentiation, and also it's per location. So if you have, let's say, if I'm an operator and I have one location downtown and one outside of downtown, I can both operate on my license, but I need 2 permits for each, and they have different fees. If that makes sense.
Yes.
Yes, sir. And to the point that was made earlier, we can easily make the adjustment. I mean, we can remove exhibit so the third map and just make some text adjustment. It shouldn't take long.
Before I propose a potential wording around the motion, any other questions or comments related to this? Okay. So this thing needs to move forward, and I would like to propose something that this commission would be comfortable passing with some reasonable edits, if you would, so that we could get this, get a motion on the floor to vote on. So I think, and Ms. Costona's helped me with this, but, happy to open the floor for some recommendations on a motion or how we would like to move forward. I would be comfortable removing the map on this page and leaving the wording, newer active applications for valet locations in other neighborhoods within Davidson County that are outside of the central business district and are not included in the outlined area in the CBD in the previous maps will be part of the non-central business district. I feel like it should be appropriate, but would open the door for other suggestions.
So I think the last page, this non-central parking district NCPD map, I would
Remove the map.
recommend removing the whole map.
Yep.
And then on page 8, where it says CPD at the end, add a parenthetical that says see attached, attachment A. And then if you go down to the NCPD, delete that parenthetical, and then you can add a parenthetical that is everywhere in Davidson County that is not in the CPD.
So essentially,
Or known as, or defined as everywhere in Davidson County that is not in the CPD.
so you're rephrasing the NCPD equals and then the verbiage after that, correct?
Yeah, so delete that.
We'd also have to go back.
Is it mentioned in a third place?
Yeah, so it's the issuance of a valet permit, may or may not result in a parking meter. It's page 4 of our sheet. And it's number 2. It says the proposed location for a valet permit area is located within Metro's parking meter zones or rights of way that constitute potential parking meter zones as shown in attachment A.
So you could do as defined here and below instead of as shown in attachment A.
Okay.
Defined here and below?
Yeah, as defined here and below, because we're defining them later on. Or whatever reference point legal prefers, sorry. I'm
Defined
just-
in attachments or whatever. So we have an edit on page, we have one edit on page 4, number 2, changing the as shown in attachment A to defined here and below.
Yes, comma, as defined here and below, striking as shown in attachment A.
Okay. And then on page 8, NCPD equals hours of operations per day in non-central business district areas, period. And deleting what's in parentheses? Striking through what's in
Yeah,
parentheses?
you can do that. Yeah, because you're right. That second parentheses would just be duplicative. So yeah, NCPD is just hours of operation per day. Well, we need to define non-central parking district, right? Or if you.
Previously before, every area in
Davidson
County.
Yeah.
Outside of the.
Okay. Yeah.
So if you're adding that language there, do we even need that last page?
Yeah, I think the last page should just be deleted. I don't think we need it.
We're deleting page 11 completely. Because you're taking the language from page 11 and putting it in that equation.
Yeah.
My number's off? I've got page 11 as the map. Just get rid of this page.
The last, yeah, that's the NCPD,
Okay,
yes.
so gone.
Yep.
Rip it off of yours so we're clear. There you go.
I'll do one better look.
We're creating this right now. So page 4, page 8, 11's gone. And then I think it may be appropriate to just, in the motion, reference any other language that is in line with NCPD or something that's called.
That needs to be made to, yeah. That's
Right.
Right. That's in line with the changes we've made, or consistent.
So do we have a motion?
So moved.
Thank you.
Ms. Costones, are we appropriate here with, we've got a motion and a second?
I hate to do it, but if you could restate it, it would be more clear.
Okay, I figured. So I'll try. So we're requesting a motion to approve the valet fee policy with edits on page 4. Number 2, changing as shown in attachment A to as defined herein below. Changing page 8, NCPD, that line saying NCPD equals hours of operations per day in non-central business or non-central parking district areas. And then saying, and then eliminating the parentheses and putting a period there. And then saying newer active applications for valet locations in other neighborhoods within Davidson County. Or, this area includes valet locations in other neighborhoods within Davidson County that are outside of the central parking district and are not included in the outline areas in attachment A. I'm probably going to have to replay this. But
We could also have Ms. Haber, who has been doing a better job than I have of keeping track of all of these, to read these back just to make sure we're all on the same page.
And then deleting page 11.
Can I ask one question
Sure.
before we jump into that? When we're on page 8, when we're talking about the equation, N is defined as the number of approved metered spaces at 22 feet. Would it be better if it's just the number of approved spaces at 22 feet each?
Yes.
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 I think so.
So we're deleting metered in how we're defining N. And then a last asterisk to this motion is anything applicable that is related to the map or in CPD to clarify we deem appropriate or we support. Is there a way for us to conditionally approve this with the edits and then provide the final version next month for
Sure.
second approval so that we can go ahead and implement this with these conditional edits?
Yeah, absolutely. I mean, that's at your discretion.
Would you be okay with that, and staff?
I don't think it would need another vote necessarily
Okay,
unless
yeah,
it
I
was
mean,
like.
We're gonna vote to do something today.
Right, I don't think
But
it would
we
need
just want to
another
ensure
vote
that
unless,
what comes back.
unless it was somehow not what you all intended.
Can we just put this with the meeting minutes and then approve it within the meeting minutes next month?
To put the marked up version?
Yes.
I think that's possible, although our meeting minutes, I believe, do have to be sometimes scanned and posted, which I'm not sure handwritten changes are gonna be, ADA accessible, for that purpose. Yes. So what we can do is, legal and staff can, get together. I think we'll go ahead and have Ms. Haber read out the whole thing, including everything that we think we've captured that you've said so far. Not the whole thing, just like the changes. Sorry, let me make that clear. And then, we'll work with staff to prepare a red line, and that red line will be part of your packet next month. And if, you can vote on it today, but if that red line does not match what you all had in mind, then you can take action next month as well.
Okay. Quick
Does that
question.
make sense?
Yeah, and this still has to go to the finance director?
Correct.
Great.
I do have a question from staff. Teresa, does that mean we would have to wait another month before we invoice or do anything with regard to that?
So, I mean, in general, the action of the commission is actually more formally adopted when the minutes are adopted at the following meeting anyway. So,
That's true.
at that point, if we make that red line a part of those minutes and y'all read it and agree, yes, that's right, I mean, you will take action to approve the minutes, then that's when that would be technically more formally adopted. That's when the person's ability to appeal that decision, their 60 days to file a petition of writ of certiorari would start running from the date the minutes are adopted.
Which is what we do every month, essentially, anyway, with items that we vote on.
Are we trying to
Right.
get this in before the fiscal year ends? Is that the?
We're trying to be honest, we're trying to make this so that we can invoice as soon as possible because the renewal is October 15th. So the longer we prolong this, the less time for the valley operators to go between 24 and 25. It's just, it would be ideal if you would be able to invoice, but I mean, it is what it is.
Yes, Councilwoman.
I mean, we adopt things all the time, right? And a sign might go up the next week, even though the minutes aren't approved until later.
That is true. That
That's
is common
correct.
practice.
So what I'm hearing is that we get a read back, then we vote, and then we'll see the red line in the meeting minutes next month to confirm what edits were applied, right?
I mean, we're gonna see them in the minutes, but I think we're proving them today, correct?
Yes.
So
Yeah, you're voting on it today.
Yeah.
In the future, you will also vote to kind of like further ratify that we got it correct in the red line that is attached as part of the minutes. So it's kind of an additional validation, if you will.
Okay, but it doesn't change the fact that we are approving them today, just like we would approve a loading zone that a sign might go up for next week if NDOT chose to go forward with implementation.
Yeah, so there is an exception to the minutes kind of thing, which is that if you adopt your motion in the form of a written resolution today, then it's effective immediately. Like in the sense of that when the 60 days for the petition for a writ of cert would run from to file that. But I mean, I think you're taking action today. Next month, you will acknowledge that staff correctly took down the minutes of the action that you took. But the action is being taken today.
Good? So we could get a quick read back, and then I will ask for a motion.
Okay. The first edit was made on page 4, number 2, and that edit is to delete the last 4 words shown in attachment A and replace it with defined herein below. The next proposed edit is on page 8. The letter N equals number of approved metered spaces at 22 feet each. We're going to remove the word metered from that sentence. The next proposed edit is with the definition of CPD. We're going to add a parenthetical there at the end of the sentence that says, see attachment A, and the parenthetical. The next proposed edit is at the definition of NCPD. We're going to remove the parenthetical that is there now. We're going to delete that in its entirety and replace it with a parenthetical that says everywhere else in Davidson County that is not part of the CPD. And then the next edit I have is to remove page 11, which is the map of the non-central parking district in its entirety. Remove it from the packet, from the policy.
Okay.
And I think that's everything.
So what I have in my notes, any other questions or comments? Do we have a motion?
So moved.
Do we have a second?
As edited.
Second.
We're not allowing questions on the motion. All in favor, say aye. All in favor, say aye. Any opposed? It has passed. Thank everyone for their hard work.
Thank you, everybody.
Thank you all for working together.
And thank you for all the work that you've been into.
Yes.
And the intervening.
Thank you for the suggestions and for making us better. Appreciate it very much.
Item 8.1, new business. 8.1 is the valet operator licensing process discussion. It's my understanding we're not voting on this. We're just educating the group on what the licensing process, and this comes back from the conversation we had or the discussion we had in last month's meeting with regards to how licenses are issued, and that there hadn't been a lot of licenses, or there hadn't been any licenses come through in a good fair amount of time, and it going through this commission was something that was a part of code. So, Ms. Costonis, if you could elaborate on that. And I know in the valet fee policy, it was spelled out what that licensing process is. Appreciate you adding that, being detailed. But wanted this commission to understand what our role is with regards to the licensing process.
So you're talking about the interpretation of section 1241.020 of the code, is that correct?
Yes.
Yeah, I'm prepared to speak on that. Hang on one second, let me make sure.
While you're doing that, Mr. Schwartz, would you still like the opportunity to speak on this item, or you just, okay? I just wanted to confirm.
Ms. Costonis, paragraph D is the one to really look at.
Yes, that is correct. I'm sorry, I just have several different tabs of code page. Yeah, here it is. All right, yes. Mr. Smith is correct. Paragraph D says, if the commission finds, and that is a reference to you all, commission is defined further up in 010 as the Metropolitan Traffic and Parking Commission or its designee. If the commission finds upon examination that the applicant is capable, willing, and qualified to provide valet services and can conform to the laws of the metropolitan government, the state of Tennessee, the United States, and the rules and regulations of the commission, again, that's that same defined term, then the department shall grant and issue to such applicant a valet operator license. Otherwise, the application shall be denied. So that's a little bit confusing because it's like it says the commission maybe makes the finding of whether they're fit, willing, and able to do this and to conform their conduct to the law. But the department issues the license. So I think maybe when you have like a brand new valet operator service, it maybe should come before the commission. There is also that language in the definition of commission that says, or their designee. So I think another option would be to delegate that authority to a designee within NDOT. But the commission, the department itself is who actually issues the license. So I think like going forward from that, like any annual renewals, the department could probably just process those administratively, because presumably you all would have already made a previous finding about that applicant as to whether they're fit, willing, and able to conform their conduct to the law. Does that make sense? That's what I got.
So we as the body are the ones who actually collect all the information. There's 7 criteria that the valet operator has to fulfill. I'm sorry, let's call it application process, during which they have to provide 7 identifiers that they comply with. And that would be simply, proof of insurance, financial responsibility, employee context, the claims process, tax ID, a tax license, and then obviously the valid location. So we do have 2 applicants here that happen to be a new valet operator that we would like to get, if we are voting on this today, to get them approved so that they can operate legally. But I would also extend that we are willing to take over the responsibility to approve valet licenses in the future, if that's something that the commission chooses to do.
So are we being asked if we want to do this, or is it required by?
So there are 2 options, because the definition of commission as used in 1241.020 is defined in 1241.020 as the Metropolitan Traffic and Parking Commission or its designee. You have the option of identifying a designee who can fulfill the role that you play in 1241.020, which is to find upon examination that the applicant is capable, willing, and qualified to provide valet services and can conform to the laws of the metropolitan government, the state of Tennessee, the United States, and the rules and regulations of the commission. So that finding is initially allowed to be made by you,
Just D only?
the TLC. But the definition of commission says it's the TLC or the TLC's designee. So if you wanted to designate someone on NDOT staff as your designee to make that finding, you could.
So A, B, and C would be done by NDOT, and I'm just talking out loud
Correct.
on the process. A, B, and C would be done by NDOT. Then it would come to us once A, B, and C is validated or verified?
So yes, I mean, staff would make sure that all of that, those documented requirements are fulfilled. But, it says, basically, the way it says upon examination also, if the commission finds upon examination that the applicant is capable, willing, and qualified to provide the valet services and can conform to the laws of the metropolitan government, the state, the U.S., and regulations of the commission, then it's the making of a finding. And you would make a finding by motion just like you would do anything else. You would say, I move to find that parking management services is qualified and capable and willing to conform their conduct to the law. And then that doesn't actually grant them a license. That's just a prerequisite finding. And then the department is the one who actually issues the license per Section D. Then the department shall grant and issue to such applicant a valet operator license, otherwise the application shall be denied. And then there's, that distinction is kind of carried through a little bit in E and F as well. E says, such license shall state the name and address of the licensee, the date of issuance, and such other information as the commission determines necessary and proper. So in terms of what they submit to be determined to meet that standard and meet that finding, you all can ask for additional information if you don't feel like you have enough information to make that finding. And then F says, a valet operator license issued by the department pursuant to this section shall be valid for a period of 1 year at an annual fee of $100. And it's not assignable or transferable, and expires upon the licensee terminating the valet service or revocation by the commission. Renewals shall be on an annual basis and shall be granted after confirmation of the extension of all applicable permit requirements. So I think like annual renewals don't have to come back before you if you have already made a finding that licensee is, meets that language in D, capable, willing, and qualified to provide valet services and can conform to the laws of the metropolitan government, the state, the U.S., and the rules and regulations of the commission.
So what do we evaluate, how do we deem somebody capable, willing, or qualified?
So because it says upon examination, I think you talk to them. And you probably
Like
read
here?
whatever applications they have submitted as well. But again, you also have the second option
Right.
of delegating that whole process to someone else.
Are we voting on that option? Do we have to vote what that option is, or is like who has the power to make that decision?
So you don't, this commission takes no action except by motion adopted by a majority of the quorum at a public meeting.
Go ahead.
I mean, I think if we're gonna delegate this, there probably needs to be a policy that sets out what we would want the department to look at. Who are the owners? Has this company or any companies owned by the owners had any complaints or issues? You know, have related companies paid their fees on time? You know, all that kind of stuff that one would look at. If I were to look at it here, that's what I'd want to know. And I think, but we would, if we're going to delegate it to the department, I just want to make sure that it's very objective, because what I don't want to happen is there not to be a policy. And if somebody comes along in the department were to want to deny that license, that is a lot of responsibility to put on the departments. And I think that's probably why it's supposed to rest with us, because they shouldn't be hard decisions, but they could be. And maybe even a process where if they don't meet a certain standard, then it gets elevated to here might be appropriate. That's what would make me comfortable delegating it, because that's what I would look at here. And then I think, which leads me to my next question, which is our 8.1.1 and 8.1.2 things that we're supposed to approve, because I don't even have those applications.
So we have them here. I'm not, we were hoping that they would be presented to you today, but I have them here, and they fulfilled all 7 of the criteria. So if, I'm not sure in which way we would distribute this, but if you'd like, you can look at them or keep them. I think the reason why it's not displayed here is so that,
Yeah.
you know, it's public information. I don't know if they want it there.
Okay, I guess I'm a little confused, because C and those 7 criteria seem different from D. And so C are criteria which I'm comfortable relying on the department to say, yes, they gave us all this information, but D is a totally different question. Are they willing and are they qualified? Probably gets to some C, but could be different, right? D isn't if we find that C is satisfied. It's a totally different criteria. And I don't have any information about these operators before me to decide whether or not they can and will conform to the laws of the metro government.
That makes sense, but I'm not sure how this can be identified if somebody's brand new to operating.
Well, I think I just said what would make me comfortable, which is who owns them? What other related companies are there out there? Have those companies paid their fees? Do those companies have complaints against them? Do these companies have complaints against them? Do they operate in other places? Do they have any issues with how they operate in those other places? If they're totally brand new, we don't know anything about them, the best we can do is probably talk to them and look at whether they're validly formed, but that's not the whole of what is possible. And I don't think we should assume that our ordinance, which sets out criteria, is something that we can't figure out what it is. It was written for a reason by council.
Yes, Councilmember, I think that a policy could be developed to cite just that, what you're talking about, but also including in the application, they need to make a statement in the application too of their experience as well, and why they feel like they will can meet the requirement of Metro law.
But that hasn't been given that to us today, so I don't know how we would make a determination based on that.
Yeah, I think if you were to delegate it, I think that would need to be developed before moving forward with approving these. I would say, based on, and Teresa can probably speak to this, based on experience with TLC, they do this type of thing very frequently when they have operators or people seeking a license come before the commission, and they are presented with, the commissioners are presented with information relative to them, and then they somewhat interview the applicants during that period. So in that way, that system is not truly fully delegated to the department in that way.
How was the last license that was issued? Do we have record of that?
I do not have record at this point.
Who currently has licenses?
I'm sorry, what was the question?
Who currently has a license?
I mean, PMC has Metropolis, Last Parking, there's several.
So we don't have record of how they got theirs. Why aren't they reapplying? Or why aren't they coming back before?
Because they are existing already.
So they just.
No, he's asking how they were licensed.
How are we deeming them capable and willing?
They are renewed.
They're just grandfathered in, I guess?
So I can speak to that a little bit because I had this come up at another commission, in fact, at TLC the other day. But there's this concept of law it's establishing case law. And it talks about the de facto versus de jure authority of a public official, like a representative of NDOT. So if a representative of NDOT appears to have the de facto authority to grant a permit, that permit is honored as valid, even if that official did not have the de jure or by law authority to issue that permit. So I think the existing ones, we don't know if maybe way back when there were some findings made about them by an earlier group of people that formed the commission, or if they were not. But even if they were not, I think certainly when the department granted the license to them, it appeared to them that the department had the de facto authority to do that. And so that we would honor those existing licenses. But I can say if you wish to make them come before you and prove that all over again, I think you can.
So you mentioned something about their applications not being public information.
No, I was just mentioning, I don't know if it would be the best idea to showcase the names, because there are references here and employee names.
And that's
security,
a part of the
social security
process?
Yeah, it's part
So
of the
all of
application
that would be
process.
public record
That's gotta
that
be
anyone
public
could
record.
ask for anytime, anyway.
Well, I mean, this number two, a name and addresses of at least two references as to the applicant's financial responsibility. Like, what are we looking for? This is for $100 annual permit fee.
Also, I wanted to make sure that it is understood. This is for somebody to be able to operate as a valet operator. This has nothing to do with the license, with the permits that they receive for each location.
This is for the license.
This is for the license only,
Right.
correct?
Right.
I think it's actually that's a pretty big deal, right? We want to make sure that they have the money should a claim be made, because they have damaged a car or hurt a person, right? I mean,
So part of,
this really gets to the meat of, is this somebody who we trust to drive other people's cars on our
it
streets?
does, and there's a requirement of $1 million for insurance, which is included in that packet as a minimum. So $1 million is a minimum.
Yeah, thank you. I wasn't quite finished. But it's not just the $100 fee, right, would be my point there. Yeah, now I'm finished.
Yeah, I mean, I would add on to that it's not just the insurance part of it, but like we asked in a previous meeting in terms of how operations work, and if we're creating an unsafe environment and making sure that they are able to pay the right amount of employees, and I think it even says applicable workers' compensation. So like they have to actually think through how many employees they have to manage all of the permits that they're trying to use. And I think that needs to be part of the discussion to make sure that they're capable and willing. Can I ask another question here of how did these 2 new permits show up?
One of them was actually a former PMC employee, as my understanding goes. And so now, I believe, and maybe Jay can speak to it, they created their own valet company. And the second one used to be a valet company, and now they're going back to being a valet company after taking a break. So these, from my understanding, as not an Nashvilleian or established, especially the second one, they used to run a valet business in the past, and now they went away from doing valet, and now they're coming back. And I believe the gentleman is here, so he can speak to it as well.
And he's an avid traffic and parking commission watcher. Did we reach out to people to solicit these, or was this just randomly you got an email after the last meeting?
It's just timing. I mean, I know last time we discussed that we hadn't had any applications and that we had to come up within the month of May. One of them actually had a business license provided in May. That's why it's in front of you in June. And the second one will literally send all the application within the last 30 days. And so he provided the packet and is looking to be approved today so that they can operate.
It's just, 2 months ago, it popped up that we're approving licenses. Was it last month or the
Last
month
month.
before last? Yeah. And then all of a sudden, a month later, we've got 2 people ready.
Yep.
And I don't even think I don't feel comfortable currently that our commission understands the process as a whole, the requirements at which, not that we're not willing or capable to do it. I mean, we've got to decide if we're going to designate or not before we even look at these applicants, is my understanding. So we've got to get to that step first and figure out as a body with legal, like, are we asking staff to recommend what they would prefer? Are we like having a discussion around what each would prefer or what not? So like, there's just a lot of, I would move, or not move, I would suggest we address, like, are we designating, are we seeing these people before we move to the next phase of getting these people approved? Yes.
I feel really bad for these applicants because I think we are sitting here, we have a job to do under the law, and we haven't been given any information with which to do that. And they're trying to run their businesses, and it's a business that we need here. I agree, we really need a process. I would be comfortable putting them both up here and asking them questions to try and see if we can get comfortable vetting them today. But I would like to be really clear that I would like a lot more information about these applicants before they show up on the agenda, should more continue to apply in the future. And I think it really makes it hard on us to do our job when we don't have any of this information and we're putting them up here and asking them questions. And it's really unfortunate. I mean, we're getting into their busy season. And maybe a question for the applicants is, do they have places identified to operate where they're seeking to get permits so that we know what their timeline is too? Because again, this seems deeply unfair to them. But also, I mean, we have a job to do and we need to do it well. And I want to make sure we're all comfortable doing it.
I appreciate that comment. And I share that same opinion. There are some of those thoughts. I think it's also unfair that we're in this position to make the decision that's comfortable and legal for our commission with regards to these. I think if we were to entertain bringing them forward today, like, are we going to get copies of these applications within the next, what is that? I feel like it's just rushed. I think that's unfair all around, per se. Could we, and I don't know the answer to this, but do we need to make a list of like these things, these 7 things and additional things that we would like to see and have them prepared to come back next month to review and approve and then implement a policy from there? Or
I mean, I think you can do any of the things that have been suggested so far. I think you can call them up.
Are both people here? I'm sorry.
Well, I don't think both of them are here. One of them is here. But again, I also have the packets if we can distribute them as you please.
Yeah, and the packets are completely public record. If you give your name and your address
Yeah,
to the government, that's not protected in any way.
We provided them in electronic form. I'm not sure why they weren't distributed before, but I have them also printed because I was anticipating some questions. So we printed them as well. I can provide those.
And there can sometimes be some information that may be protected within an application. Like with the address, it's almost never protected. The only instance I can think where an address is protected is where someone is a victim of domestic violence who has or stalking, who has like a existing court-ordered protective order of some kind that requires their information about where they live to be kept confidential because they are in that much danger, in which case there's this, and I've never had this come up, but there's a process for presenting that court order to the government and the government acknowledging it and then deleting the address from what's provided in response to a public records request. Yeah, I mean, there could be somebody might be paying a filing fee and put their credit card number in there or something like that. That would be protected. Certain individual identifying information, driver's license numbers would be protected. So there can be some information in a packet that may not be absolute public record. I'm sorry, it looks like Mr. Smith has something to add.
I'd just also like to point out too, it's not just the applicant, but section C4 also says that the names and home addresses of all employees.
Yeah, no, that is not protected.
It's not just them.
Yeah, that is not protected information. That is in the public record. That is requestable by anyone with a public records request at any time.
So how do we
That's
go?
the cost of doing business with the government.
How do we go about making a decision right now if we're going to interview the gentleman that's here or not?
I think that is up to you all. I think you can go ahead and decide to interview him now. I think you can either subsequently or before that make a decision about whether, I guess I would say probably subsequently make a decision about whether in future you want to delegate that responsibility. But you have not delegated it to date. So given, if you were to approve anything today, I think you would have to make a motion making the finding in 1241.020D.
Do we have to make a motion and vote on the decision of if we're interviewing the person?
Yeah, upon examination, you put the applicant in a chair in front of a microphone and
No, I'm saying
ask them questions.
make a motion to bring him up is what
You could do that too.
make a motion to decide to bring them up to, okay.
I think because their item is on the agenda, they can just come on up.
Are
But
you on the agenda, Mr. Schwartz?
No, I was just going to call out what Mr. Smith said, and I think what Manuel was saying, the issue isn't putting the businesses' public information out there, whether it be their
Doesn't
insurances.
matter.
Part of the application process for every valet company started in 2011, and it does request for every valet attendant to provide their driver's license and their home address. And that is what, like I know for us as a business, asking a valet attendant that is working a seasonal job to put that public record out there would be a concern on our part, when really it's.
Hold on. So just for clarity here, I think that's the public record piece
Yeah,
and the
that is up
documents,
to
that's
the-
outside of
that's up
this
to the state
commission.
legislature to
Yeah, I mean,
determine what.
that's, we're not here to discuss and or decide what's public and what's not. I think the gentleman which application is here? Which person? Representing who? Which LLC is he representing? Okay, hold tight. You had a quick question.
Yeah, so
Corner six.
I'm assuming that because that hasn't been passed out yet, it's not technically in the public record.
It is, just by being submitted to the doc.
It wasn't
Just by being
to us.
submitted to the department, it becomes a public record.
But we haven't seen it. The commission hasn't seen it.
It's still just because the department received it.
We would have to do an open record.
Someone would have to do an open records request in order to receive a copy of it, but it would be a public record already without you all having seen it.
That's right. So I guess, do we want to interview, what's your name, sir? Do we want to just ask Mr. Harper questions to see if he's ready to be interviewed for this and then move from there or decide from there as a group?
I have a statement.
Sure.
I think an interview would be good so we can see where he's at in this process. And then from there, the commission, can make a decision on where to go. Everything you said was great, it was perfect, about getting the information that this body needs to make a good decision. But by talking to this gentleman, it might give us more information as to where he's at in this process, and it will help the commission make a better decision.
So greatly appreciate that. I think, let's do it. If you don't mind, state your name and your company for the record.
Daniel Harper, Geritana Parking LLC.
Okay. And I would suggest we just go around the room and propose questions, and then if others come up.
Do we need to move on from the item that we were doing a discussion on this, and now we're moving on to the actual item?
So this is a sub-item of that item. Ms. Costones, I guess, we're doing the valet operator licensing process.
Yeah, I mean,
Right.
8.1 just now says valet operator licensing process discussion. Now, just because you say discussion doesn't mean that you can't take action on something as it's worded on an agenda, by my understanding of notice requirements of the Open Records Act. But it does kind of hint in the direction that the staff wasn't necessarily expecting the commission to have to make a vote on that. But
So I
that
guess.
doesn't mean you can't. You can.
Sure. I think great point. I would ask in fairness to volunteer valet, since we're giving this man the opportunity, I would propose a motion to defer this person's process to next month's meeting. Do we have a second on that? For volunteer valet only, for 8.1.1.
I'll second.
So it's been first and second. Any questions on the motion?
So it's just on the one who's not here.
It's just the
We're
one
gonna
that's
hear
listed
out
on
there.
this agenda. Since he's not here, in all fairness, he should get the same opportunity as we're giving Giratana Parking LLC. All in favor, say aye.
Aye.
Has it been opposed? So that has passed. So that item, or volunteer valet, would y'all please notify that entity? They will have the opportunity to interview before us next month's meeting. And we'll move forward with them based on what we learned from today.
Chair, I would say a motion may be good to recommend that, or request the department to develop policy in the future, so this is not a problem moving forward, so that it's clearly understood how it should work and how we should be treating everyone.
Great point. So let's reverse to item 8.1, valet operator licensing process discussion. I would ask the commission make a motion for staff to provide a policy around 12.41.020 with relation to commission and item D, and also make a recommendation around a designated person from staff potentially for our consideration. Do I have someone to make a motion for that? Or a revision to my motion, my asked motion?
I think my only issue with that is an assumption that we're going to defer it, and I would want to know a little bit more about why others, I think you said TLC doesn't, they do it themselves, and I think what might be helpful is like a presentation on what other groups do, and then a discussion among us as to what we might want, and then we can move forward with maybe putting that to paper might make me more comfortable.
Okay. I'm all for that. We can entertain that motion around a presentation of what other commissions do and a proposal of what you all would recommend.
Yep, that's what I would do.
Included in that.
Yeah.
So is that your official motion?
Sure, yes. If that's what others want, I'll make that motion.
If there's a second to that motion?
Second.
Chair, I would say just based on TLC, there is an opportunity for you as a commission to establish have a special called meeting even between the next time if you would like to, because I know that TLC does that at times, specifically for these situations where they're reviewing licenses or they're talking about policy and process. So I just wanted to point out that is an opportunity that the commission has.
Thank you for that. It's been first and second. All in favor, say aye.
Aye.
Any opposed? So that has passed for a presentation and recommendations for item 8.1 on our valet operator licensing process. Okay. Remind me your name again. I'm so sorry. I'm going to write it down.
Daniel Harper.
Daniel Harper.
If I may, before he gets started, is there some type of a checklist that these different companies have to go through, and those are items that you are presented to you, and then you say, okay, this has been done, this has been done, this has been done? Can that be presented to this group?
That's a good question. The answer is yes, and those are part of the packets that are distributed now. So the application itself has all the criteria that need to be met, and then there are attachment in the application as part of the application packets that are here today.
And those are going to get passed out?
See only one copy here. Is there only one copy of his? Are these, this is for volunteer valet? Yeah.
So while we're doing that, Mr. Harper, if you don't mind, just give us a brief history about yourself and your company and what you intend to do with your business.
All right. I'm the Director of Parking Operations for Giratana Parking LLC. I have 10 years of experience at a senior level parking operations with another company, SP Plus. And Tony Giratana, Anthony Giratana, our owner of Giratana Parking, was the founder of Premier Parking and operated that for many years, then selling it. And now he operates a development company. And the intent of our company is to initially manage the parking operations of our own residential buildings.
Okay, thank you. From there, I will open up to the commission for any questions or comment for Mr. Harper.
How did you hear about our new process?
Through Mr. Matias with filing for the operating permits and stuff for location.
Thank you. Sorry that you're caught up in all this today, but I appreciate your willingness to answer questions.
Great learning experience.
For everyone.
It'll make the future go smoother.
Right. So it sounds like you have some experience. I know your owners have quite a bit of experience, which will hopefully make this easier because you're not trying to create something from a bunch of folks who haven't done this before. I just want to make sure I know that is SP Plus operating in Davidson County today? Or they want to? Or okay.
Well, SP Plus is no longer. They were part of the buyout with Metropolis, so now they're part of Metropolis.
Yeah, I'm lucky them, I suppose. Okay, so I just want to make sure that you're aware of sort of the changing ways in which we're treating valets and valet fees and permits and licenses.
Yes, ma'am.
And you're willing to abide by those rules as we promulgate them and NDOT enforces them?
Absolutely.
Okay, thank you.
You said that these are your private apartment buildings, or is there one, is it more than one location?
We currently operate 2 buildings that have existing valets. One is the alcove at 900 Church Street, and the other is the 505 at 505 Church Street. Those are buildings that we own that have a current valet.
So these are not new applications?
These are new applications. We made a decision to terminate the valet operator that we had at the alcove and start our own company to manage that property.
If I might just jump in real quick, and that the reason why this is happening also is because the licenses are not transferable. So if there's a company A operating and company B takes over, it has to go through the process. And this is both for license and the permits per location.
So the permit remains active, but if it doesn't have an operator, then it can't be utilized. So once they're an operator, they didn't transfer that permit to their license? Or do they have to apply for a new permit?
I believe the permits are not transferable either. So per location, they would need to apply for the permits as well.
So there's
Unless
no valet operation?
Correct. Yeah, permits and license, Brendan with NDOT and LAS. Permits are not transferable and neither are licensed. Currently, they are the permit holder for the location. So they don't have a license, so they need to come before you to get permissions to actually be an operator in the city since they're new.
Who's they? Who has the permit?
Giratana.
Giratana has
the developer.
Correct.
So they are correct, yes.
Now they're coming before you because they need to do business to be a valet operator because they transitioned from A to now them being B. Since the license is not transferable, they're coming before you to get approval to be an operator.
And just refresh so a licensed operator or a building owner can't apply for a permit, but an operator has to operate that permit.
Can you rephrase that? Sorry, you confused me there.
So yes, if you are a business or like an owner of a building.
Right.
And you are the applicant on the permit location, you would still have to hire a
Right.
licensed operator to run
Right.
your valet stand.
So that's why he's getting his, or Garetana LLC is getting their license as an operator to operate the permit that the building owner currently has. Correct. Okay.
Then they outsource to somebody else, correct? So now they're taking it back in-house.
I've been able to confirm that both licenses and permits are not transferable for Chapter 12.
So as long as Garrett, the building owner, developer maintains that permit, then the operator just assumes it once they're hired as an operator.
I mean,
Or they don't assume the permit, but they're operating
I
under
think
the
it
owner's
depends
permit.
how the permit was applied for. If it was applied for in the name of the developer, then I think that would be correct. If it was applied for in the name of the valet operator, then I think that it would not be transferable and they would have to reapply.
So we're verifying that history.
That has happened with this application, yes, sir.
Okay. Pedestrian safety is obviously paramount to this commission. Can you talk about your all's safety procedures and approaches and how you onboard your employees to maintain safety within the right-of-way and as you're operating each permit?
As far as onboarding our employees, we have a process in place where we do, of course, criminal background check, motor vehicle records check of all of our employees. All employees hired, even if they're experienced valets or new valets, they are still put through a extenuous training program that, allows them to work alongside another experienced valet to, while they learn all the policies and procedures, as far as safety for our lane, as far as safety within our garage, and all aspects of where we operate. We take safety, very serious, in all of those different locations.
Captain or Councilman, do y'all have any questions?
How long did the process take for you to get to being in front of us here now today?
Since March, around the start of, beginning of March.
Would you mind elaborating on that process a little bit?
We made application with NDOT. We knew we already had the permit in our name as the developer. The whole process of getting what was the name of I'm trying to differentiate between the two things, the permit and the operating license, right? So we, was definitely some gray area on how to obtain the license. And so Mr. Matias walked us through the process, got us the appropriate paperwork. We provided all of the documentation within, a very short period of time to him. All the insurance and asset information that was requested. And then now we've just been kind of waiting through this process to get the actual approval and get the license.
How long has it been since you all have been without a company with an operating license?
Since March 1st.
And is there a way we can pull up these locations on Google Maps and look at them today? Is that even possible?
Corb, is that possible? Could you repeat those addresses if you don't, you said 505 Church?
505 Church and 900 Church. They both have lay-by lanes that we established during construction and where the valet operates at. They're not operating in the street.
If I may, to be clear though, the commission is not being asked to approve those permit locations at this time, only being asked to approve the operator license.
While he works on
Would you
that.
still like to see the map?
That's fine.
Yep.
How many employees do you currently have identified for this license?
We around 16 to 20.
Is it 16 or is it 20? Because you submitted in there. Is it the numbers in there?
Yeah, how many employees do we have on there? We submitted. initial hiring process, we hired more than we were going to need because obviously when you start a new business, people won't show up and and stuff during the hiring process to actually get the boots on the ground. So I'm not sure of the initial number that we have on here from back then.
And is your intention to have them kind of rotate around between both of
Well,
the locations that you may get?
Yes, sir. We currently only are operating the Alcove Valet at 900 Church Street. We were just recently, SP Plus has been operating the 505. We just recently received on this past Friday as part of the divestiture with Metropolis and SP Plus. They notified us that they will be assigning that contract and no longer able to operate it. So we're going to give them a termination on that and take the 505 Valet in sometime where we're hoping with all the approvals and everything for around August 1st for the second location.
You're not operating currently, right?
We are.
Without a license?
We are. I mean, we made the move to do this, thinking that all we had to have was the permit. It was after we already got started that we found out about this process for the application. We made all of the information that was requested. The process wasn't explained extremely well, and what the actual process was and how long it was going to take to get this part of it done.
I mean, I'll say it. We just had our approved policy, and there was supposed to be fines for operating without a license.
How many days?
Yeah, I mean, I think we then have to be fair to go back and say, we're supposed to have you licensed before you're operating.
Correct. And we understand the process now, and, we will accept whatever responsibilities we have to take to, to get things in order here. But it has been kind of a really gray process as we've navigated through it. We're just trying to, our goal is to be 100% in compliance with everything, and as we move forward and grow our company even more.
So number 4 says the applicant will provide the department with the names and home addresses of all employees to be used or employed by the applicant in the business of providing valet services. The applicant shall provide an update upon each renewal of license. Pretty broad. To my fellow commissioners' questions, is it 16 or 20? Do we have 16 or 20 names and home addresses of all employees? And, operator today gets a license, has one permit location that requires 5 people. Say they get 10 more over the life, we're not asking for updated information until the renewal of next year, just as a clarification? Is that how that's interpreted?
We can ask for an update at any point.
At any point?
Correct.
Okay.
Yep. And that's
But they're not required to provide any update until the renewal?
Actually, they are as per code, as if my memory serves me well. So any terminations or anything to that extent would be have to be communicated.
And, go ahead, Mr. I don't want to lose sight of the operating without a license and the fees imposed to that, but you go ahead.
I'm just gonna ask what was the date that you started operating?
March 1st.
Okay. Thank you.
So then, on item D, where it says applicant is capable, willing, and qualified, we talked about, and can conform to the laws of the Metropolitan government the state of Tennessee, United States, and the rules and regulations of the commission, do we feel like that they're operating within the rules and regulations of the commission to qualify to provide an application, knowing that they're operating without a license? That's a question for staff.
It's a good question. That's a good question. If they are willing to conform to the fines and therefore become compliant and also get the license, I'm comfortable with having them as a licensed operator.
So I appreciate your willingness to be here today and to be open about the fact that you've been operating without a license. It's a little over $5,000 for license fees, and depending on the location of the valet, potentially permit fees, but we actually don't have permit applications before us. So I think that means you'll be continuing to operate without a permit if we grant the license today, which means technically you would not be operating and following the laws going forward.
Ma'am, we have the permit as the owner of the building. The permit was made in our name even when the third-party operator was operating it. We've had the permit all along. That's why we thought that we could take over the operation. And this was a very, very quick decision based on some operational issues that were occurring. We thought we were we thought we were able to do this, and then the licensing part of it came up after that had already taken place, that we needed to do the licensing part.
I understand that you think you have a permit, but my understanding is that permits are non-transferable, correct?
That is correct, but if the permit was obtained in the name of the developer, then there would not be a need to transfer it.
Got it. Thank you for clarifying. And so that permit is in the name of the developer. It is, ma'am. Okay. Well, that is at least easier. I appreciate that you are here and willing to do this. I think my question is, could we make a motion that it is approved subject to the payment of all fines owed? I don't know if that's valid. I don't know if people want to do that. So those are two separate questions, probably one this direction.
I think we'll table that request and still field more questions or comments from the commission for now.
Yeah, I mean, I just, do we have fines? I mean, we passed something today, but that's not technically passed.
Well, that's, if I may, that's part of the fees were passed today as part of the policy that was passed. The amendments we have to make will be voted on in the upcoming TMP, which was at page 4, 8, and the last page.
I mean, the fines. Yeah, so are those in effect already? Or are they not in effect until a different date?
I think so the question is, did we have any penalties in effect yesterday?
Yes.
Yes.
That would probably be the best way to look at it.
Yeah,
The time period between March 1st and an hour ago.
Yes, so I think that's a question for NDOT and legal. Did fees exist before today? Or fines for not having a license exist before today?
I'm sorry, the question is for us whether a fine has been issued before?
Well, since we just passed this fine today,
Yes.
it was not in effect yesterday. So the question is, what would the fine have been March 1 until, as my colleague said, an hour ago?
That is correct. So generally, the presumption is that anything that is adopted laws or regulations are going to be prospective in effect. So in general, a law is not retrospective in effect unless there's a very clear statement made that that is the intent. And also, I think there's some distinction in case law between procedural and substantive whether it is procedural or substantive. If it is procedural, I think sometimes it can be retroactive. If it is substantive, it very much can't be. So in general, what I would say here is that, yes, if you adopted the policy today, providing for the $50 fines, then we could not retroactively apply it back to March 1.
But there is a code provision in 1241-100 that says violators shall be fined $50 for failure to comply with the provisions of this chapter, or failure to operate a valet service in the manner prescribed by this chapter. Further, each day the violation continues shall constitute a separate offense. All fines paid pursuant to this section will be deposited into the general fund of the Metropolitan government.
So that would go to the...
Subsection A.
So that's actually enacted by council as part of the chapter ordinance, already providing that a more general violation of chapter 1241 will also result in a $50 fine. The $50 fine is also just kind of the default amount that we use in Metro for code violations. Usually it can be cumulative, it can be per violation per day.
So that would go to the developer then and not this LLC? Because the developer is operating.
Yes, whatever party was doing the illegal operation, it would go to that party.
Okay. So a question on item C, it says that the necessary and proper paperwork, the commission determines to be necessary and proper, including but not limited to the following information. Items 1 through 7 are listed there. All of items 1 through 7 not included in what you provided us. So where on the screen here, item C, number, where it says item C, and then there at the end it says commission determines to be necessary and proper, including but not limited to the following information. So number 1, which I think is this first page, I can't find number 2 in this paperwork.
It's in there. There's 2 references in there.
Okay. I guess my general question is all of these, have we confirmed that all?
Yeah, we have them on our end. I'm not sure what happened.
What is this? That's the complaints and the claims.
There's a page about it.
Oh, I don't think we have that. Oh, I missed it. Okay. So we have confirmed that all this, everything listed here is here.
Correct.
Okay. Thank you for providing that. It's on the back side of that. Number 2. Captain Jones, you asked for the map. Do we want to pull that back up?
I'm good, sir.
Okay.
I'm good, sir.
So the names and the addresses of the employees, where is that? The complete screening?
So I actually didn't see addresses of employees. I
There's
saw
no addresses.
phone numbers and emails. I do think that phone numbers can be withheld if they're unpublished, and emails can be withheld if they are personal emails. So emails ending in @Gmail or @Yahoo are generally going to be personal emails that could be redacted. I think that's for everyone. All right, that might be wrong. We're going to have to look that up. A household address is not protected in any way.
Another question for legal, with
His
the
name and home address.
the information about compensation, minimum wage, labor laws, should we be expecting to see that in here as well, since it's specified? Is that something we can ask?
I mean, I think that's at your discretion. The section does say that the commission can ask for any other information that they deem necessary. So it's kind of like what you need for your comfort level to make the finding that's provided for in 1241-020D.
What's the process with them operating without the license? Do they continue, or do we shut them, stop them, or what does that process look like?
I mean, after today, if we're saying that that policy, well, not just the policy, but the existing code provision has existed all this time, then yes. I mean, you can put other conditions on your motion. You can say, we'll grant your motion contingent on you paying past fees. We'll grant your motion on contingent on use. I mean, I guess it doesn't really make sense. If you're granting them an operating license, then they don't have to cease operating. But
It doesn't feel like a very good precedent to approve licenses that are not in compliance.
it might be relevant to the ability of the applicant to conform their conduct to metro and state and federal law and rules and regulations. If the violator and the applicant are the same entity, which they may not be.
I will say, I think that this has been shifting and loose. And so while the laws have for a long time said one thing, we've sort of operated in a very different manner. As I think evidenced by the fact that we have not been approving licenses, right? And I do appreciate the willingness, again, of the applicant to come and admit this and to give us a date, which seems to be backed up by some of the paperwork, like filings on February 29th and in the month preceding that. And I do think the applicant has demonstrated a willingness to, going forward, conform to the law, and I would be okay approving it so long as it were subject to payment of all fines, and so the license could not be issued until those fines were paid, further demonstrating a willingness to comply with the law.
Can I ask one more question? The complaints or claims as a parking operator, and this is just send you an email. Do you have history of dealing with complaints and
Absolutely.
and how do you try to resolve them?
A complaint is started, an investigation is started on it immediately from the time that it's reported. We give them, they can report it to somebody at the valet podium, in which then they take information and it's forwarded to myself, or they can email. Our email is posted in the building at the concierge desk if they have any issues or claims or so, how they can get a hold of us. We start a claims process immediately, and we turn it over typically within 24 hours to Travelers, our insurance company, and they actually handle the claim in its entirety from there. They reach out to the person who has the claim. They gather all the information, they process and pay and take care of it, and then they send us an invoice for it.
So what if it's a situation of improper employee behavior?
Oh, well, those are all handled internally, through our HR department.
So I share the opinion of our commissioners in the sense that I appreciate you coming forward and being honest. This process hasn't been fully baked and solidified prior to you or you applying for this application, and how it was presented, in my opinion, should have been a little bit better to our commission. I still have the opinion that it shares rushed in how this has transpired over the last couple months with related to the licensing. I do understand, Councilwoman, that your willingness to come up here and be honest is something that is admirable, and the position of the statement that, you didn't know you had to do it, so you're doing something when you found out. Not only do we continue, but there's got to be checks and balances with staff too to say, hey, you can't operate without a license, or come before us with this special meeting, if you will, to say, hey, we have a situation here. Commission, we need a special meeting to address this specific situation for a developer that has something that's undefined, right, which didn't happen. So it's not all your fault. I think there's some checks and balances there too with regards to how, you can't just bring an application in here without a process or procedures within us to then say we need you to approve it, when the fact of the matter is they've been operating without the right stuff knowingly, and we should have identified that and brought it to us. I do also agree with the commissioner in a sense, precedent here matters, right? For lack of a better phrase, letting someone slide or saying, hey, we don't want to set the precedent to where other people that are in a similar situation where it's going to happen over the next few months as we're baking our procedure or policies, don't look at this video or read the meeting minutes and say, well, this entity just got slapped a fine, so we can just operate until we get our, because that's going to be the general consensus moving forward. I think it's a lot of pressure on this commission and myself to present a motion out of feeling and or just comfortability. So I would refer to the policy that we just approved in the sense that penalties for operating without a permit, operating without a valet parking license or permit will yield a fee for the operator's belated application, and in the case of operating without a permit, a sign reimbursement fee and interim costs, $50 per day. But it also says any violations of Metro Code may result in the consequence of a notice to suspend or revoke the license or permit being issued pursuant to Metro Code. And the license or permit the license or permittee will have to request a hearing to go before the commission and show cause why this disciplinary action should not be imposed. If a license or permit is revoked for such a violation, the former licensee or permittee may not submit a new application for a license or permit until the following calendar year. I don't think it's fair to do that, okay? Given the gray area of this policy, given the gray area of where we are with it, revoking or removing it for a calendar year, I wouldn't suggest this commission make a motion to do. I would like to entertain a motion to approve your license pending that all fees are paid, and that we impose an additional penalty of double the existing fees, that they can then ask for and request for a hearing to then come back and show cause why this disciplinary action should not be imposed. And if you all can come back during that hearing and prove to us that that's the case, I would entertain that. Where I'm reading this now, we could impose the disciplinary action as necessary.
Yes, in terms of revocation and suspension, that kind of thing, absolutely you can. In terms of penalty amounts, there is some Supreme Court authority that suggests, or I think it's actually in the Tennessee Constitution, that no fine of over $50 can be upheld by a court unless the person is given an opportunity to have a jury trial. And so in general, that's why we set our fines at $50 is consistently, is to not run afoul of that. So it's a little tricky because this is an administrative procedure, but it is appealable to the courts for further enforcement. And so I think sticking with just not doubling the fines, but just the $50 a day would be more consistent with that Supreme Court case law.
Okay, well then I'll say it this way. I don't feel that it sets a good precedent to just say, pay the fine, you can have your license. There's got to be something in addition to that we can impose while still allowing them to operate and approve them. Because I think they're capable, right? There's history there, but there's got to be we've got to regulate this precedent that we're just going to turn a blind eye and let them write a check.
Sorry, can I just make a suggestion possibly to have a probationary period?
Yeah,
or
probation is allowed.
I'm open. I just, whether that's a week or, what's that, is that revoking or suspending the license for a week or a month or a probationary period? What are the terms of this probation like? How do we define that?
So they would have to go and whatever period of time we would agree here to go without any violation and to pay the fees.
I would defer to the commission on how they would support or recommendation as to what the feeling is there, any other suggestions. What I would like a motion to come before here is fees applied, an approved license, and some sort of probation or additional penalty to not set a precedent that this is okay. So I'll open up the floor.
I would be amenable to a short probation period. Oh, Ms. Casonas, I'm sorry.
No, I'm sorry, I didn't mean to interrupt.
No,
I
please.
was just going to say, we were looking at this further, and the ability to issue the suspension, revocation, or probation is subject to the applicant being able to get a hearing on specifically that. And I'm not sure that this applicant was noticed that he would come here today and face disciplinary action. I think he just thought he was going to have his application considered, so we might need to.
It's just unfortunate. I think the commission has done everything we can to approve and or accommodate every avenue or every part to this with regard to our process, how we've approached it. The law just doesn't allow us to address this today.
Can I make one quick statement?
Sure.
Before you guys make your final decision. Again, we're willing to accept responsibility, fines, et cetera. We did make these applications, immediately upon request. They were turned in. There has been a lengthy period between that before this motion came before, or this application process came before the council, which is not necessarily our issue that it's taken so long for it to come forward. We were also never, once the information was, all the information was given to NDOT, at no time were we asked to cease operation or told that, we could not operate, or that we were subject to being fined or anything. Like I said, this whole process has been very gray from the start. And we just kind of thought that, it was a waiting period to come before the commission, but because we had the permit, we turned in all the paperwork, that, we didn't feel like we were necessarily operating without a permit to the degree that, now we're in a situation where, we might be denied the permit or what have you. We've been very transparent about what we've done, and we've done everything that we can to operate within the guidelines, file paperwork. We've submitted it as quickly as it was asked for. I hand delivered it to Matthias the same day that he asked for it. And so I ask that, you reconsider, that, and somehow can adopt a motion that does allow us to receive an application today. Again, we're not objectionable to pay fines, but I would also ask that you take into consideration those factors, that there has been such a lengthy period of time to get this before the commission, and the fact that, we were never really told, hey, you can't operate. They are well aware that we have been operating all this time, that we've had lots of communication, and at no time were we asked to cease operation or to, that we were not in compliance and we were operating illegally or anything like that.
I appreciate that, and that's why I think this commission in good faith, wants to find a way to allow you to operate. I will say the first paragraph of the application says, effective September 1st, 2011, no person shall engage in the business of valet parking within the area of the metropolitan government without first obtaining and keeping in force a license from the commission as a valet operator, provided that no such license shall be required for persons conducting or offering valet parking services solely on private property without involving the use of any public right-of-way. So understand that when you got there, you didn't know, but you knew when you filled it out, or somebody knew, right? So there's a whole host of fallacies here. It's just.
I absolutely agree that there was notice on that form. I am concerned that maybe at no point did our department tell you to stop operating because you were operating without a license, or suggest that that was actually in violation of policy. It concerns me for the next person coming before this board as well. So I hope that if that person is operating, that staff will inform them that they should not be operating without a license, and maybe they will have the opportunity to cure that and pay fines before they get before this commission. I think it's really, really tough. If we had not changed so much in the past couple months, I would not be leaning toward where I am on this, but it's just how much we have changed that makes me a little bit more sympathetic to the violation.
Yeah, so I think I agree with the councilwoman, and I think I want to just remind the commissioners that this all came about when one of the commissioners asked a question probably 2 meetings ago about whether we issued valet permits or not. So we had no idea we did until the commission.
Valet license, operator license.
Yes. And so we had no idea until then. So I think we have to take that into consideration. And not only that, but I think that if we wanted to and we wanted to proceed with licensing the operator, I think that we can say that from this day forward, which is the day that we have voted on the valet policy fees, we can then set a precedence that from this day forward, and only from this day forward, and make this the first day that operators will receive this type of consideration and not operators, but this operator will receive this type of consideration from the commission, because like he said, and like we've all been agreed, this has been a gray area for the last couple of months, and something that we had no idea we were part of, or part of the discussion until now. And I think that we're just learning that we still weren't part of the discussion when the department took this application.
I'd jump in on that. I understand what you're saying, and I also agree that I'd like to try to find a way to keep this going. In terms of applying for the application, having that start on a date, there was a time period of staff not enforcing what we're supposed to be enforcing. So even if it was brand new to the commission itself, they knew that they were supposed to be getting an operator's license approved because it was submitted before we had that discussion. So that it's not new to the department, it may be new to some of the commissioners that are here. Part of this, you had said that you had a former operator that's there, and why you're trying to go into this new business plan is to change that. There was operational issues. Are you willing to kind of talk through some of those operational issues
We just had a lot of operational issues. We had continuous complaints from residents regarding different aspects of the valet. We had an extensive amount of claims, $65,000 worth of claims in a 8 month, stand. Continuous, we have lots of documented complaints of valets driving residents' vehicles without permission, their cars smelling like marijuana, just lots of different complaints that were leading to residents terminating their leases with us because of that, or asking for concessions. It just became a nonstop avenue, and ownership just felt like they had to step in, and they said, obviously Mr. Giarratana has been in the parking industry himself for a lot of years, and he said we can do this better ourselves. And we made a decision to do so, and everything did kind of go very quickly. We did pull everything together, and I understand what you're saying as far as the verbiage on the application. I guess in our opinion, or what we thought, and again, I'm not saying that it's wrong or it's right, we felt like once we submitted all the documentation to NDOT, we sort of thought, we felt the presence of the approval to operate based on the fact that all the documentation was turned in, and that the formality for getting it officially approved was maybe not necessary to operate. And, I understand that there's a different perspective of that today, but I think Mr. Matias here will agree with me that at the time that we did all of this, again, we didn't think that we were operating illegally. We felt like once we submitted all the information based on conversations back and forth between him and I, and the fact that we had the permit long-standing before that, because we own the building, we own the permit for the valet, we didn't necessarily intend to break the law and operate illegally to the sense of how it's been portrayed today. But we understand your stance on that and your understanding of the law. But again, we feel like there was a lot of gray area there, and it was never our intent to stand before the commission today and, have to defend what we did. More so, we felt like we had done what was necessary to be able to operate. When I turned in all the insurance information to him, he verified the permit was in our name, and that was kind of a very important factor in our communication back and forth with Matias, was that the permit was in our name, and so we kind of got the "you're good" consensus once all that was turned in. And again, it's been no secret that we've been operating the valet. It hasn't been with any intent to hide it from NDOT or from this commission since we did that documentation.
Those previous complaints that caused this operational concern, were those shared with NDOT?
I don't know as if they were actually shared with NDOT as far as sharing the emails with them, but I mean, I have a folder this thick in my desk drawer of all the, complaints that come in via email from residents and so forth. Many emails back and forth with the operator, Metropolis, concerning these and so forth. So, again, and I don't want to get into hashing out all that with Metropolis, but I mean, that was the defining moments that we used to make the decision to have to step in and do something differently in order to protect our investment and our leaseholders there at the building.
I think that information like that should be part of your complaints process, to where you're willing to share it with NDOT, so that way they understand if there are concerns as well as you dealing with them personally. I think that from your previous operator, I think it would be a good faith effort to share that, because that sounds like an operator that is operating within the city that we should be paying attention to as well, because if it's just one building, I don't think that should be the case. It's probably all buildings, so there's probably an opportunity to go in and look at other claims. I continue to think, if we're willing to approve this today, I think we can do that. They're going to have to be enforced fines. I don't think we have an ability to set fines as this commission. I think that's part of the department has to go in and figure out when they've not been in compliance and do that work. So I think it's just dependent on us to approve them or not.
So yes, the code provides for fines or penalty amounts for the violations, and the department could, if it wished to, just directly pursue those without the commission having to impose those penalties.
Lesson two also, if there's a situation like this in the future, those instances or complaints or cases, special hearing, or we need to get this on the agenda next month. We've got an owner that has, somebody they've got to remove, and they're bringing their own operation. They have a history and they're capable and all that. Like that's what, if we would have started with some of that stuff, a month ago, or when it initially arose in March, put it on to April, I think that those are situations where special circumstances would apply, and that this commission would say, yeah, this owner has a history, he's got some issues with his current what have you, and needs a special provision to operate, would be acceptable.
That makes sense. I just wanted to point out that we had one of the criteria to fulfill within these 7 is the business tax license. We got the filing acknowledgement, but not the actual form itself, and that was received in May. That's why this is in front of you in June. So,
Gotcha.
Just wanted to make that clear.
Any other questions or comments?
So what I'm hearing is the application was not complete until we received the...
Well, we didn't have all the documentation until recently.
So at this juncture, I'm going to open up for a motion and be totally open to whatever the commission perceives is fair and right in this instance.
I have a question for legal. You had mentioned before that he's not here under the impression he didn't know he was going to get penalized.
That applies to the disciplinary hearings. It applies to being suspended, having your existing license revoked, or being placed on probation. The penalty provision that Ms. Haber read prior is actually in a different section of the code. And the way that would be pursued is if the department wanted to pursue it, would be through an environmental court, which generally handles matters of Metro Code violations. I did have one other thought. I don't think it's necessarily what you want to do, but I'll share it if you think it's helpful. Just that, because we do have to have the advance notice for the hearing, if you were to grant the license today, you could also send a notice for the next commission meeting at which suspension, revocation, or probation could be considered. But that's up to you.
Can this body forgive a percentage of fines? Is that possible?
I mean, I think that the department would probably defer to this body on that. I mean, I think the department could go to environmental court and seek the full amount of the fines, but I think that they look to this commission for guidance, and Mr. Freeze was just nodding, so.
Yeah, we would defer to the commission as far as the.
So I've been making some notes over here, and just bear with me. If I don't say this right, but we can issue a temporary license for 30 days or 60 days, is that?
I don't know that they would provision for
But it can be a probationary license.
that. Well, yeah, probation is disciplinary action, so you can't put them on probation until we've given them that notice that they're going to have to defend themselves against a disciplinary proceeding at which they have the right to like bring an attorney with them and some witnesses or whatever other defense they want to put up. So that's the problem is, yes, you can place the license on probation, but only after they have received, written notice of the charges pursuant to 1241-060.
Does it give a time frame on the written notice of the charges?
No action to suspend, revoke, or place on probation any license or permit provided for in this chapter shall be taken by the commission until a licensee or permittee has been furnished a written statement of the charges and a notice of the time and place of the hearing to be held thereon. The furnishing of such notice and the reasons for the commission's proposed action shall be given to such licensee or permittee at least 15 days prior to the date of the hearing.
Okay.
And so we would have to give the license and then give written notice of putting them on probation.
I'm just saying that's an option. I'm not saying that's what you should do.
If we were to go that path, we would
could do that.
we would be giving them the license and then giving them written notification of probation.
Or the charges for them to come to a hearing.
Yeah.
And then make your determination based on the evidence before you. Right.
But the probation of the disciplinary is only. The probation of the disciplinary can't be monetary.
Yes, the probation can only be imposed on pursuant to 1241-060, hearing before suspension, revocation, or probation. I still think that the original motion that you could grant the license on the condition that they voluntarily pay the $50 for the days that they operated without a license would also be a valid motion.
Can this body, because there has been some gray area, to kind of bring the needle back, can this body forgive like 50% of the fines?
Oh, go ahead. No, sir. I mean, it's just right at $5,000, which I think is a fair fine, given that this was statutory. This is a statutory fine, not our adopted fine. So there wasn't any gray area in the statute, as far as I read it.
You could determine that, like, maybe the penalty would be imposed beginning on the date that they actually submitted the application. Oh, wait, that was March 1st, wasn't it? Okay, never mind.
Did the council add those days? Councilwoman, did you
So
come up
that
with
if those were the days,
There's an online calculator. If you Google time and date calculator, if you're a real estate lawyer, you know how to do this. And you put it in. It's really lovely.
Captain Jones is done.
You're going somewhere.
No.
I'm in between the council and the sergeant. I'm for approving the license, and finding a happy medium, finding a fair resolution to the fines being imposed?
So I guess at this point, we need an emotion, an official motion.
Yeah, you could do all three also. You could make the motion to approve, subject to the payment of the fines, and then also instruct staff to send them a notice for the July meeting at which charges of violating the code may be heard and discipline, including probation, may be considered.
So, good question, comment?
The first time you said it, you said we had to make it voluntary.
Oh, I mean, when I said voluntary, I just meant because it would be a condition, it wouldn't really be voluntary. It would just be a condition on, like, instead of us having to go to environmental court and get a judgment for $5,000, that they would just agree to go ahead and pay the $5,000 as a condition of their license being granted.
So I would propose someone make a motion that we award them a license, an operating license, pending they pay the appropriate fines that are appropriately calculated, and that the next day charges are sent and they come before this commission for consideration of additional disciplinary action. Do we have a motion?
Mr. Chairman, I move that the company voluntarily pay the fine that has been established, that we grant the license today, and that the regulatory body send them notification that they will be brought before this committee for the possibility of probation.
Do I have a second?
A second.
It's been first and second. Any questions or comments on the motion?
I just want to clarify that the motion that the license is conditioned upon the payment of the fine and that those aren't separate.
Yes.
Thank you.
Any other questions or comment on the motion? It's been first and second. All those in favor say aye.
Aye.
Do we have opposed? Again, I want to say it has passed. Again, I want to appreciate you coming up here impromptu and going through this process. Understand that the situation that has gone through since March to now, it's very admirable, it's understandable, and we appreciate you being diligent through this process.
Thank you, and we appreciate your time and your consideration to make this happen.
Thank you. So item 9.0, other business. We did want to talk about Second Avenue.
That's correct. I believe you have one more item on the agenda here before
yes,
that.
sir.
I'm sorry.
It's
I'm
a
jumping.
briefing, yeah.
Item 8.2, and I'll be brief. At the last month, Vice Chair Woods asked for information about crashes and fatal crashes, and in particular pedestrian crashes. I just wanted to highlight that in the agenda analysis report this month. This data is provided from the Vision Zero Advisory Committee, which meets on the second Tuesday of the month at 5 p.m. in this room. So if anybody has more interest in finding out about the Vision Zero Advisory Committee, there's a web link in the staff report and a kind of a record of roadway fatalities to date in 2024 compared to 2023. The other item of interest is a enhanced pavement markings project that we're undertaking to improve pedestrian safety and to assist drivers recognition that they're in school zones. This is something NDOT will be installing during the summer We've prioritized the school zones that we know that are in the Vision Zero high injury network and rank them according to the severity of that network. And we're starting with the top 15. And this is in your staff report. There's an example of what some of these enhanced markings look like. This is not necessarily what every road's going to get. but it depends on the road classification and the number of lanes. Some markings are more intensive or more, like I said, it depends on really the number of lanes that's adjacent to the schools. The list of schools are shown in the staff report, and work will be underway on this project this week. And with that, that's the last item that I have for 8.2.
Any questions or comments on this item? Appreciate your diligence in providing this information, and moving forward with projects that help and enhance pedestrian safety along this high-injury network corridor. With that, we'll move on to item 9.0, the TIZ for Second Avenue. I believe Ms. Scobel, if you will.
Yes,
and Mr.
Michelle
Freeze.
Scopel's here with us. Yes, thank you. Thank you, Chair.
Just please state your name for the record, and you have the floor.
Yeah, I was going to say a bit of an introduction here. So as you know, back in May, the council voted to approve the tourist improvement zone. That was the legislation that was 2024-306, I believe, was the ordinance actually that was approved. So with that, it actually established that 22-month period that we have talked about previously. You heard Councilmember Coopin mention that at the top of our commission meeting today. So I wanted to go back, and we're just going to provide a brief update with regard to that. So I brought up the website here so you could see, actually, we put a home for this on the website so that applicants can go in there and read a little bit more information about it, but also we put out an application for them to do. So I understand during the April meeting, there was a lot of discussion about how are we going to protect safety, during these periods of time. Are we going to review these? So this application period is set up just to do that. So we can actually have that proper review period. We are anticipating to do some in-person meetings after they complete an application. So that's really what we wanted to provide an update with that regard. Also clarifying what Councilmember Coopin said earlier about there was a misunderstanding as far as the way it was communicated in the legislation with the minutes in their meeting that there was a misunderstanding whether it was supposed to be closed for the entire duration, the entire section of the street in there. That was never the core intent of the department and working with the stakeholders. It was meant to be closed to vehicle traffic during the construction. So when active construction was on different sections of the roadway. So this is a multi-phase, multi-year project. So it was always anticipated that when different sections open, that they would be open to traffic. But this was a method to help encourage and provide opportunities to those businesses to increase foot traffic in those areas where they're closed to construction, but also throughout the whole scope of the area where you can actually do some things that are beyond what currently Metro Code allows. So when we started this process, we actually started with a special zone ordinance that are typically written for like the 4th of July or other events. They're like the CMA. There's an ordinance that typically goes through for those as well. So we started that as a template. When we worked through that template, there must have been some language that got caught in that template that said that would be closed permanently to vehicle traffic the entire time, which was a misunderstanding. So I just wanted to clear that up too. And I know that Councilmember Coopin mentioned that earlier too. So I was just providing further clarification with that. And I can,
with the chair's permission, I wanted to just kind of add to that like one of the things that my department does is that we assist departments in drafting legislation. And I think it was me who actually put that language about the street being closed to traffic in the draft ordinance early on, which was just based on my office, front Second Avenue, and it was very obviously closed at the time. And, had some past discussions and past matters that we've dealt with about the possibility of pedestrian-only zones, and so I misunderstood what I was being instructed to do in drafting the ordinance and included that language, and then Mr. Fraze and the council member caught it in time to make that amendment before it passed, to delete it out.
Yes. So now I'm going to turn it over to Michelle to actually provide an update on current applications and give you a little bit of context on as far as the early stakeholder engagement with regard to this, when we were talking to all the business owners and how that they did a quite extensive stakeholder engagement as part of this project, the MDHA, the Second Avenue project. So she can give you some insight with regard to that background.
Thanks. Thanks, everybody. Thanks for letting me kind of jump in on the end of the meeting here. I'm Michelle Scopel with MDHA. I'm in charge of leading the design and construction efforts of Second Avenue Rebuild on behalf of the city. So it's been a group effort really all the way through with MDHA, NDOT, planning, mayor's office, and really great collaboration actually with a lot of folks. So, so as you all know, this blast happened 3.5 years ago now, during a pandemic, mind you. And so the businesses along Second Avenue and everybody buildings, businesses that were affected physically by the blast are still struggling with that. And then of course anybody who's worked through construction themselves at home or nearby, you understand how challenging that can be. So while we have worked very hard as a construction team to really minimize the impact at the front door as much as possible, which is why we have phased our construction the way that we have, it does maintain pedestrian access to all of the businesses on both sides of the street at all times. So that's one of our main objectives, because of course you have to keep the businesses in motion in business. I believe I've recently heard a stat about 40-something% of the businesses at the time of the blast have left. So, you know, the businesses that are remaining, that are still open, we are working diligently to make sure that the construction is not something that tips the scales in the wrong direction for them. So that's been really the main driver for something like this, for this desire to help activate the sidewalks. A lot of these businesses are just trying to get people literally down the sidewalk and into their doors. And so some of that is with signage, the A-frame signage boards, sometimes putting speakers outside where normally it's not allowed in this area. And a few other things like activating the street. So I think this piece of legislation that was kind of created is a great response to a lot of the complaints that we've had and a lot of the fears that we've had from the businesses. And so really, once this was implemented, we actually had a community meeting. We've probably had 35 to 40 community meetings at this point in the last 3.5 years. And spoke to everybody, and Brad, Mr. Freeze was there, the councilman was there. We were able to kind of introduce this tourism improvement zone that was at the time had just passed, I believe. So kind of gave some information. And since then, you know, myself and the team, we've really established great relationships with everybody. Of course, we're at their front door a lot. So we've gotten to know a lot of folks, have really shared this application process with a number of them who I think could immediately benefit from this. And so we're working with them right now to kind of walk through this process again. You know, almost everything we're doing on Second Avenue is new. So a lot of this is we're working through the process together for this. And this is another example of that. While there are special event zones and special event permits, there's nothing like this for this length of time, really with this intent. So I think, you know, right now, I don't know if you all are aware of this, but we actually opened the north block. We've completed construction. It was a 12-month process. That's the block probably out by your door that you see from Church up to Union. And that was last Monday, and which was really exciting. And of course, at that time, I think there was a lot of excitement from everybody who's out there. But then anybody who, you know, kind of got used to the street being closed to vehicle traffic during construction, I think started to ask the question, hey, wait a minute, you know, is this open to traffic again? You know, part of the design process, and I'm happy to go into more background on all of that if that's something you're interested in. I've got plenty of data and presentations I can bring in another time if you'd like. But, we have done a really extensive community engagement process with all of the stakeholders. And that's those business owners, building owners, merchants, residents, everybody who was directly affected with the blast, along with the Downtown Partnership, Civic Design Center, a lot of the partners here. And through that process, we were able to see, what did you like? What didn't you like from Second Avenue? What are ways that we can put this back in a better way? Second Avenue is very beloved. It's kind of the old school place to hang out in Nashville for the locals. And so we're trying to bring that vibe back, essentially. And that was really one of the biggest pieces from the community engagement is create a space for locals. Some of the ideas of having a pedestrian-only street, that is something that actually came up during this process early on in 2021 for Second Avenue and First Avenue. And so what we did as a group, and this was a large group, including the ULI, the Urban Land Institute, a lot of experts came together, started to look at how could we do that? How can we make this a more pedestrian-focused space, but yet still have the functionality of the businesses? And so that's one of the things that we've really worked hard on. We've got, loading, delivery, musician drop-off, a lot of loading delivery. We've got garages, waste, loading docks, that kind of thing that we really have to maintain access to. So we also at the time had the Connect Downtown, which was just about to start its study at that time. So what we were able to do was take a 4-lane asphalt road, which is Second Avenue. There were 2 travel lanes and 2 parking lanes, and basically remove the on-street parking and give that space back to the pedestrian. So we've been able to create a design that really meets that pedestrian-focused space, really large sidewalks. And you're gonna notice that a little bit more on the other 2 blocks than on the north block. It's a little bit more narrow just on that section. But on the other 2, it's gonna be 22 to 25-foot sidewalks on either side. This is huge. It's really big. It's gonna be definitely a very pedestrian-focused zone with mid-block crossings, which provide a very clear, visual, safe passage for people to cross in the middle of the street instead of sort of like it is right now. They're long blocks. So really the design, the intent of everything that we're doing is very pedestrian-focused. And we're really excited about that. And then also having some ability to be able to, at times, do things like special events and whatnot. And I think this TIS legislation, right now is going to be something that's very helpful for the remainder of construction, which is through 2025, towards the end of next year. So that's something that, again, keeping the businesses that are still there, keeping them in business is high priority. So that is a very helpful thing. But moving beyond that, I think there's, plenty of opportunity for events to happen and the street to become a pedestrian street at times if desired. So that was one of the things, is making sure we're flexible with that. So with the design. So that's really what we see now. I mean, I think with this legislation that you guys looked at in April and was passed through council and that's now in place, I'm anticipating a couple of applications coming in the next week or 2 that will immediately help some of these businesses that are, have obviously been affected for 3.5 years now, which is wonderful. So we're really appreciative of that. And again, I'm happy to go into more detail. This is a little bit of information on what seems like a lot of pretty large project with a lot of different pieces to it. So happy to answer any questions you have now or come back at another time and provide additional detail if you'd like.
Yeah, I'll add a couple other things too. So the application can be accessed from the website here, and then that's the entryway, right, into actually, they're required to enter in what they're actually doing, the space that they're going to need. So that is what we as INDOT are going to take and coordinate with the other metro departments in the review process. And that was something I remember in April that was a concern, is how we manage this, how we do it safely in there. So that's really the kickoff to that. So we anticipate having a lot of in-person meetings when we get this started.
Great. Appreciate that information and update. Any questions from anybody on the commission?
Thank you for the update. I think when you volunteered to be here tonight, you did not realize that it would be like 7:17.
No, I did not.
So thank you for that. I really, really appreciate that. It's not, I think, the legislation that concerns me. I think the legislation provides some flexibility, which is what was intended. I think what is concerning to me is that I sat here, I sat there, but close to here, just a couple months ago and had a conversation with staff where we talked about this would be a really great example of how open streets can work downtown because people don't believe that open streets can work downtown. And it turns out that wasn't what was intended. And while I understand there was some confusion, I would just, I don't think open streets is a confusing term. It's like a common term. And I understand, it's different people at the table today than at that day. So I don't want anybody to, this isn't personal to anybody, but a lot of people were really excited about the idea of an open Second Avenue, a car-free zone downtown that could prove that it could work without businesses losing money where businesses actually make money. And it's, I think, just a little sad to everybody, but, there's not much to be done about that now. So we'll see how the permits roll in and see how it goes.
So I will add, Councilmember, that open streets is still, as a concept, is going to be continued to explore downtown for events and different programs. I know you know this, but we're talking about that. It does not mean that in the future there won't be open street events on 2nd Avenue. So it's actually set up very nicely, the way the infrastructure has been designed out there to lend itself to those events.
Thank you, sir.
We've actually, just to add to what Mr. Freeze said, we actually have added in all 3 blocks additional electrical outlets at each tree well, just available for special events. So, I mean, I absolutely see, and that's been part of an really design intent is the flexibility to, if there is a special event, a July 4th, a, draft, a Preds playoff, or just a special weekend that
just a beautiful spring day.
Exactly. A day that maybe locals can take over, go figure. Yeah, I think that there's a lot of opportunity to do that. And as part of the design process, we have absolutely put into place measures for that. So
thank you. Tuesdays are good. Okay, for locals,
Sure.
It's the one day, I don't know if anybody knows this, you can get a reservation.
Yeah.
So if you want to do something for locals, maybe open it up on a Tuesday.
Noted. I'll remember. Thank you.
Yeah, I appreciate you sticking with us. I'm sorry you had to stay so long. I would love to see updated information as it becomes available. I was very excited to hear about this process. I probably am part of the reason why you're here today as some of the accelerant of it. I felt like we were all on the same page and we had talked through staff and we had used language that was very specific about this street being closed for 2 years. That's not the case. It would have been nice during that meeting that would have been brought up to say, this is not what was happening. This was not the intent. So in the future, if we have those opportunities, to be clear would be fantastic.
Do we have an understanding of, or have a forecast of how many applicants we're expecting, or what's the interest been like so far with this process?
Great question. I hope that there are many applicants. I think, as this information comes out, more people understand how it could actually benefit their business. I think we'll see more and more. I'm working closely with a couple of businesses right now, just walking through the process. So I think once we have a few through and start to see that success story, others will follow suit. Also see some opportunity for things like maybe the downtown partnership or someone like that to have a special event permit for something like a Tuesday event for locals. Pop-up events, especially when the South Block from Broadway to Union, once we're finished with construction on that block, there's a little bit more space. I guess you're not in the construction zone on that segment anymore, so I think there's more opportunity for that to really be utilized for these pop-up events kind of thing, again, to activate. I mean, the goal is to get people back on 2nd Avenue, and, there's already tourists downtown, so we're really trying to tug at the heartstrings of the locals to come out and support longtime businesses on Second Avenue. And I think hopefully we'll see some interesting pop-ups that maybe will be on a Tuesday.
Great. Any other comments, questions? Thank you for fighting through and staying. We appreciate the update and look forward to more updates in the future.
Thank you very much.
One other item, I had a call come in, unrelated to that. I had a call come in from a nonprofit business that asked me where to find road closures, and I sent them to the newsletter and the link in the newsletter, and they were able to go into that link and successfully find, if there was a permit pull or for that road closure or whatnot. So that is
Success story.
It was good to share that to them and lead them in the right direction and forward them that email. So continue to update information in the way that you do. It is being used. At least it was used once last week. So just wanted to provide a compliment in the fact that
Thanks for
that
the
was
feedback.
a success.
Greatly appreciate it.
Successful process. Any other? Would you like to adjourn?
Motion to adjourn.
Approved. Thank you, everybody.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.